Dear honorable audience, dear friends, dear colleagues, thank you for gathering at the conference and also at the third session, which is dedicated to the most appropriate options for justice. And the aim of our discussion is quite a complex one. We have a very full panel of distinguished speakers, both academics and practitioners specializing in different spheres of criminal and international law. And our aim today is to discuss the restricted possibilities of universal jurisdiction, the general absence or restrictions of the ICC jurisdiction, the potentials of a special tribunal, special international tribunal on crimes against humanity, and its mode, jurisdiction, composition, and functioning. We have 6 guests, 6 international and national speakers here live, and we should have 2 panelists online. And we will be speaking in English and in Lithuanian, hopefully. So, dear colleagues, let me start with a short introduction of our guests, and then we will follow. We will proceed with short initial remarks of the guests, of the speakers, that I ask to be very, very short, about 3 to 5 minutes. And then we will have questions for you, first of all from me, and then from the audience. So, dear colleagues, as we do not have, as I see, yet the online participants, I would like to start with Mr. Saulius Verseckas, who is the Deputy Prosecutor General. He's to my right. He's the Deputy Prosecutor General of the Republic of Lithuania. He has been working in the Prosecutor's Office for almost 30 years, 20 of which in the field of organized crime and corruption. Mr. Verseckas participated together with other colleagues in the pre-trial investigation and also before the court in the criminal case here in Lithuania regarding the murder of the officers of the Medininkai customs post. And in this case, the commission of a crime against humanity was proven for the first time in Lithuania. The prosecutors proved that Riga OMON militiamen committed murder against the officials of the Republic of Lithuania while supporting the then repressive policy of the USSR with regard to the newly independent Lithuania and its people. And 4 persons who committed this crime are sentenced to life imprisonment currently, 3 of them in absentia. Tai labai trumpai, gerbiamas ponas Verseckas yra generalinės prokurorės pavaduotojas, prokuratūroje dirba beveik 30 metų, 20 iš jų dirbo organizuotų nusikaltimų ir korupcinių nusikaltimų srityje.
I'd like to present the first speaker, Deputy Prosecutor General Saulius Verseckas. He's been working in the prosecutor's office for 30 years, 20 of which in the field of organized crime and corruption.
Do not intervene in the criminal policy of another state. However, when states and their officials themselves turn into perpetrators of crimes against humanity and war crimes, they turn into those who commit crimes against the people of their own state or become aggressors against other states or their people. The reaction and active action of the international community and other states is necessary to clarify, investigate, and implement justice for such crimes, to prosecute and punish guilty persons. Mr. Verseckas, would you care to elaborate on this point?
Hello to all the participants, and many thanks to the organizers for the conference. I see so many distinguished experts and audience. so many speakers on the topics. Indeed, the topic of Ukraine is very painful today. It is also complex, and it has pushed the issue of Belarus into the background. However, we cannot forget about the situation in Belarus, because Russian and Belarusian regimes are not only criminal, they endanger the Belarusian and Ukrainian nations. They are a big, huge to the entire Europe and to the global rule of law. Therefore, democratic states must pool their forces and harness such risks. We law enforcement officials and prosecutors are obliged to collect evidence and to seek justice for the victims and liability for the perpetrators. Human rights under the rule of Lukashenka have never been respected. They've never been ensured, as everybody could see. Very soon after Lukashenka became the president, human rights were undermined. Before the elections in 2020, it seemed we can be hopeful about the Belarusian nation and its resolution to fight the oppression. On the other hand, we could see the force of repressions by the regime against its own people. They made effort to lock everybody in their own apartment. They tried to oppress the freedom of speech and confine it to domestic kitchen units only. I believe the time will come and Belarusians will be out on the streets again, and eventually the regime will change. I'm sorry for taking too much time, but all the events started in 2020, and we as prosecutors were certain we must open a pre-trial investigation into the crimes against humanity. We saw the need and necessity to help Belarusians fight against the regime and to protect victims of the regime. Therefore, we launched the pre-trial investigation. We realized it would not be easy. The pre-trial investigation of the crimes committed abroad in the state which is not cooperative, in the state which is a perpetrator, it meant the investigation would be difficult. Yet we had no doubts we must pursue in our efforts. It was necessary to collect evidence to make it possible to use the evidence for prosecution. As in the case of Lithuania, if we had not collected the evidence 20 years ago, it would have been impossible to get justice in our own proceedings concerning the killings of our customs officers. I believe all together it's possible to find solutions to get justice.
And as we've heard, Lithuania was one of the cases to initiate criminal proceedings in Lithuania based on universal jurisdiction. We will have questions to follow up on this case, but I would like to continue with our second panelist, and it is Miss Isabel Fassfurther, who is a legal advisor at the Berlin-based human rights organization, European Center for Constitutional and Human Rights. And as member of the ECCHR's program on international crimes and accountability, she, inter alia, supports survivors of crimes against humanity and torture committed in Belarus through legal interventions based on universal jurisdiction. And in her academic research in international law, she has moreover been considering how recognition of governments is influenced by international law, foreseeing certain standards of legitimacy. So once again, we will later ask for Isabel's comments on how to best prosecute Belarusian authorities in foreign domestic courts, and based on universal jurisdiction, and also maybe on the novel possibilities for such investigations. But Isabel, the floor is yours for any initial comments that you'd like on the topic.
Yeah, thank you very much. Thank you also for the invitation to the organizers. I'm very happy to be here and participate in this important discussion. And maybe as an initial comment, to just echo on some of the points that we have already heard just now, but also earlier. As the European Center for Constitution and Human Rights, we actually filed one complaint supporting survivors of crimes against humanity in Germany in 2021, but are currently faced with reluctance to open investigations. So the general prosecutor in Germany is still monitoring the situation. We can, of course, only speculate on the reasons for that, but some very important points that I would like to mention in this regard are that it is definitely very important to keep collecting the evidence and to also aggregate the evidence to meet the thresholds for crimes against humanity. So, for example, in Germany, the practice so far has been rather restrictive, but there have been cases that have been opened. As many of you might know, for example, there have been successful cases on state torture in Syria that were just recently decided upon and also judged as crimes against humanity. And what was crucial there was that it was possible to have a lot of evidence, a lot of witness testimony, so it was very important to have many refugees that had come to Germany and that could testify on the atrocities there as survivors or witnesses. And of course also the vast amount of evidence in form of pictures, for example. So I would like to echo that the work of the International Accountability Platform is very crucial in this regard, but also of the other monitoring missions. And then, of course, this is also a question of resources and political will. And what we would hope for is that the current momentum that we see with regard to Ukraine and universal jurisdiction and its application there would actually help in the cases of Belarus as well, and not push them to the background, but just to the contrary, to use the increased cooperation that we see, for example, within the framework of Eurojust, the implementation of databases there, the increased exchange of prosecutors. So we believe that this momentum should be applied to all cases indifferently. And I would also like to echo what Professor Benedek said earlier. We also believe that it always has to be a survivor-centered approach. So it is very important, particularly in these cases as the one of Belarus, where there's an ongoing repression, where the regime is still in power, to always keep in mind that survivors testifying in these cases are possibly being intimidated, that they need psychosocial support at all times, and we are convinced that this is a very important aspect and should be at the center of universal jurisdiction proceedings.
Mm-hmm. Thank you so much. Next we have, and I'm pleased to introduce to you Dr. Marieke de Hoen. She is a senior counsel and co-founder and director of the Netherlands Office of the International Law and Policy Group, and she's also an assistant professor at the University of Amsterdam. Marieke, we have now heard the initial comments about universal jurisdiction, and since we are lacking the online participants, my question to you, maybe you could briefly explain to the audience what universal jurisdiction essentially means. And maybe you could also share your initial comments on what the audience has already heard in session 1 and other previous sessions. Is it true that we have heard some skepticism with regard to any possible solutions and options for justice in respect of Lukashenka's regime? How would you look at this? Universal jurisdiction is just one of the concepts that we come and stumble upon. So once again, maybe you can comment on what it basically means and how optimistic are you about investigations launched on the basis of universal jurisdiction in general and maybe with regard to other possibilities. So Marieke, thank you.
Thank you so much. There's a lot of questions, so help me if I forget some of them. Thank you everyone for welcoming me also here, and especially the Center, the Law and Democracy Center, for also inviting me to contribute to this report on identifying, qualifying these violations as crimes against humanity. And so, as you all know, this is a report that's under construction. We're not ready yet. Actually, we've just started a few weeks ago. So we've already done a lot of work on this, but it's also an invitation to all of you to help us construct the right arguments and help us include the important facts that we are building. And so very briefly, and then I'll move to the universal jurisdiction from that, there was a discussion on the contextual elements on state policy. And actually, like, that's not such a difficult high threshold. It's actively encouraged, that a state has actively encouraged or promoted these crimes. Well, you know, like in Belarus, that's a bit of a no-brainer, right? And so there are really a lot of facts that we already have, and if we've written in the report, that allow also looking at similar patterns that is important for this policy element and for the widespread and systematic. And so for the contextual elements, I think we really have a very strong case to say that there's a reasonable basis, reasonable grounds to believe that crimes against humanity have been committed. And then the next sets of chapters is all about sort of which crimes then, and then the last part is about what can you do about it. Well, it's hard, but it's important to establish, and this is the answer to your question, what universal jurisdiction is. It is important to establish that these are not just crimes, because obviously there are many crimes being committed, but also that they reach the threshold of crimes against humanity, because universal jurisdiction means prosecution in a foreign country when there's no other personal principal link to it. So there's no territorial link, you're in a different country, but also the perpetrator, suspect, isn't of the nationality of the country that is prosecuting, nor is the victim. And so what that universal jurisdiction is limited to is those international crimes that are recognized, such as crimes against humanity. The challenge, though, is that usually, and pretty much all practice points out to that so far, is that universal jurisdiction tends to only be exercised when the suspect is on the territory of a country for the actual prosecutions. So thankfully, there's quite a few states among you here, Lithuania, that are able to already investigate some of these crimes prior to the suspect actually being on the territory. But for instance, my country, the Netherlands, isn't able to do that. And so there's a developing practice for universal jurisdiction, but I think it's also important to remain cognizant and aware that the amounts of cases will be very limited on the universal jurisdiction. And we're also going to talk about the International Criminal Court, which has a similar, like there might be some possibilities, but it probably will be limited. And of course, we criminal lawyers always think, domestic prosecutions You know, ideally they're in Belarus. So you can think, well, with all the opposition, hopefully soon there's going to be a regime change. But there as well, we need to be realistic, because a lot of these crimes are also committed by the current judiciary, as the Law and Democracy Center also shows in their report. So how realistic is it that very soon Belarus will be able to take on all of these huge amounts of criminal cases by themselves? And so I think that the interesting and important task for all of us is to then think, okay, so that leaves a huge impunity gap. I think there's a likelihood that there will be some cases, you know, but for instance on the universal jurisdiction, but not for the vast majority of those cases. And so us, bunch of lawyers here in this room, how can we come up with good creative solutions to try and limit the impunity?
Thank you so much. Yes, indeed, lawyers are usually criticized for providing too many solutions, and then at the end, none or not one that would be most suitable. And that is why our hope here is to prove those skeptics wrong, right? And I'm very honored to introduce to you our next guest, Professor Alex Whitening, who is the acting specialist prosecutor of the Kosovo Specialist Prosecutor's Office, where he has worked for the last 4 years. And previously, he has served at 2 other international tribunals, the International Criminal Tribunal for the former Yugoslavia and the International Criminal Court. And Professor Whitening has also taught as a professor of law from practice at Harvard Law School. So Professor Whitening, I remember having you here about roughly 1 year ago on a similar panel with regard to Putin's regime and the responsibility of Russia for war crimes and the crime of aggression. Taking into account Lukashenka's regime and the crimes against humanity being committed, and this has already been quite unanimously concluded during the previous panels. What unique aspects of the situation in Belarus would you like to identify, and what do you think is the most important aspects that are worth mentioning for those who are looking for options to hold Lukashenka's regime accountable? And how is this situation in Belarus different from the accountability perspective than that, in Russia?
Well, thank you. And thank you to the Ministry of Justice and to the Law and Democracy Project for holding this conference and inviting me. I think it's interesting because I was reflecting as I was listening today about having been here a year ago, and actually the main point I'm going to make is sort of similar to the one I made a year ago, and I'll get to that. But I also think that I'm speaking from the perspective as a prosecutor, and what I'm looking for is actually not what's unique about this situation, but what's similar, right, in terms of how this is like other cases of crimes against humanity. And my perspective on that is that the case and the evidence that's been presented and all the indications are that this fits right in the heartland of crimes against humanity cases in terms of the targeting of political opponents, widespread and systematic, and I agree with the previous panels that it seems to be both, indications of a policy, and then specific crimes. I agree with Professor Asensio from the previous panel that as a prosecutor, prosecutors tend to think both idealistically and strategically. They straddle those two worlds, but in the end, try to think strategically, and I would focus on the crimes in detention, and not even so much the arbitrary detention, for the reasons that Professor Asensio said, but the crimes in detention and the particularly grave crimes in detention, murder, torture, sexual violence. That's where I would focus the energy. I think there's obviously there's indications of strong evidence in that regard. To answer your question now and to tie it back to the crime of aggression, I think there's sort of agreement that there's not going to be a tribunal tomorrow. The ICC is not going to take the case tomorrow. As Marika said, the universal jurisdiction is a partial solution. So right now we're stuck with kind of partial solutions. And what I think the most important thing we can do today, and here I'm going to echo Isabel actually and Professor Benedict from the earlier panel, is the work of preserving evidence for a future tribunal. And we have Kate Vineswaran, yeah, great, and Lisa Bersay, who are both working for the International Accountability Platform. And I think that we should triple, quadruple, whatever your budget and your staff. And I hope you'll have a chance to say a word, because the evidence is now. The evidence is right now. It's available now, and as we sit here, evidence is being lost, is disappearing, and it has to be captured. And it's not so much the standard of proof, reasonable, it's like it's about the quality of the evidence and how it's collected and preserved, and doing that to a criminal standard, which is very complicated in terms of thinking about consent of witnesses, protecting witnesses, and capturing corroboration. We can get into more detail about that later, but that's the main thing that I would do.
Mm-hmm. Thank you so much. Thank you. I would like to continue with Mr. Arif Ibrahim, who is a barrister, writer, and speaker specializing in international criminal law and public international law, including international human rights law and international arbitration. Mr. Arif advises policymakers, NGOs, states, and international organizations, including the UN, widely on constitutional issues, peace building, and international crimes. And Mr. Abraham is recognized as a leading barrister in international law in chambers and partners from the year 2021 until the present. And once again, just as Professor Whitening, Mr. Ibrahim was present with us 1 year ago. And I remember your very systematic approach towards all the options for accountability for the authoritarian regimes. With regard to Lukashenko's regime, maybe you could present to our audience how you see it. What are, even if partial, as was mentioned here, what are those main options for accountability and justice at the end? Thank you.
Thank you very much. And can I also begin by thanking the Ministry of Justice and the Law and Democracy Center for today's invitation, and for obviously all of you being present and listening through these talks. I guess what I can seek to do is to try and navigate what everybody else has said and try and answer the gauntlet that has been set by Marike about what are possible solutions, and maybe even consider some radical alternatives to what we generally hear when it comes to accountability and justice. To take firstly the ICC, so we've heard from a number of speakers now that one way for the ICC to get jurisdiction is to look at the unlawful conduct that happens on the territories of current states parties, so Lithuania, Latvia, Poland. So if you have, for instance, forcible unlawful deportation from Belarus to one of these countries, then one of these countries can refer the situation to the International Criminal Court, as have NGOs to the present day. And that the International Criminal Court has said can be extended to the crime of persecution as a crime against humanity, on the basis that some of the harm, that is, for instance, serious human rights violations in Belarus, also extends and crosses the border into these countries. And that principle can probably be extended with some work to other crimes like enforced disappearances and obviously the forcible transfer of children from Ukraine into Belarus. So obviously that's a real and available prospect.
But there's a but, right?
There's an alternative too. So that precedent comes from Myanmar. Another Myanmar precedent that we haven't yet talked about is the idea that, for instance, Myanmar's National Unity Government made a declaration to the International Criminal Court to say to the court that actually the junta in Myanmar is not the lawful government and therefore is not the lawful representative of the state. Similarly, you may argue, and it's slightly more difficult in the Belarusian case, that the United Transitional Cabinet is actually the lawful government and therefore the lawful representative of the Belarusian state, and therefore it decides to self-refer to the International Criminal Court. Now, there are some hurdles. In the case of the National Unity Government, the government was already in power and there was a coup, and also the National Unity Government was recognized by the UN General Assembly, but that is a possibility available to the United Transitional Cabinet. So that's just something to think about. There is obviously the special tribunal route, and maybe I'll leave the difficulties with that to the questions and answers. And the difficulties are obvious. I mean, it's difficult for Ukraine itself to establish a special tribunal. Yes, sorry. It's difficult for Ukraine to do it in respect of Russia, but it'll be even harder for Belarus in respect of the Belarusian case. Obviously, the way it could be done is either through a multilateral treaty or a UN General Assembly resolution, however unlikely that is. The reality is that if a special tribunal is created, that it would have limited international support, and a tribunal with limited international support may not be characterized as an international tribunal. And if it's not an international tribunal, then you have problems of personal immunities. You'll have problems with apprehending perpetrators, because there's not many countries who will sign up to the court or tribunal, and you'll have problems with enforcement. So what is a possible radical kind of alternative? And we want to push the envelope of the law here. And I think some consideration should be given to a people's tribunal. So people's tribunals first started with the Vietnam War, and Bertrand Russell was one of the very first people to set up essentially a court or tribunal with obviously no binding powers, but essentially citizens, practitioners, civil society, sometimes backed by governments, can come together to say, well, there may not be a formal mechanism, but there is binding international law. So who can apply this law to the situation that exists? And so if, for instance, the United Transitional Cabinet, together with relevant state supporters, together with declared third parties, were to instruct a team of international judges and prosecutors and provide an institutional structure to create a tribunal, maybe base it in The Hague, that tribunal could be seized with a single task. Is or is not the Belarusian regime carrying out crimes against humanity, and who is individually criminally responsible? And of course, what that does is it replicates a court process, not in order to create a binding judgment, but to set down an authoritative decision as to whether this is happening and who is responsible. And what that does in a case like Belarus, where there's relatively limited international attention, is it changes the narrative. And by changing the narrative, you raise awareness, you put perpetrators on notice about the crimes they're committing, you allow the evidence that's been gathered and processed and analyzed to be used in other processes like universal jurisdiction. And eventually, the hope would be that if the political situation in Belarus changes, then of course, the tribunal's decision or judgment could be extremely authoritative for a future domestic Belarusian tribunal. So I think a lot of attention and focus should be perhaps focused on this, because people's tribunals can work really well. They're a tiny fraction of the cost of a real tribunal, and they can have significant impact. So I worked on the Uyghur tribunal, which was in respect of China, and that had a massive international impact, to the extent that the Chinese state had sanctioned the tribunal, and it had done a whole campaign to delegitimize the work of the tribunal and its authoritative finding.
Mm-hmm. Thank you so much. We will definitely come back to the concept and the possibility of a tribunal. But I'm happy to announce right now that we have one more panelist online with us, Mr. Mateusz Pezdirc. Do we have the panelist, perhaps?
Good afternoon.
Pezdirc, thank you, and we're very, very happy to have you. Mr. Pezdirc has been working with Eurojust since 2011 as the head of the Secretariat to the Genocide Network. And before this, he was the head of the Criminal Law Unit at the Ministry of Justice in Slovenia and has also worked in Brussels and with the ICTY in The Hague. Mr. Pezdirc is a criminal lawyer with a lot of international experience, right? And as he is representing the Genocide Network at Eurojust, I would like to first of all ask you a very general question. Maybe you can present to the audience and maybe those who are not so acquainted with it, what is the Genocide Network and what does it do and how does it operate?
Many thanks, and many thanks to the organizers for the invitation. Also, apologies for not being able with you today in person, and thank you for facilitating possibility to join you remotely. Now, as I have joined, I see the discussion is very much intense and going in the good directions. So a few words from my side. First of all, the Genocide Network is a platform for national authorities. We connect 33 national jurisdictions beside the EU member states, also several observer countries, and ICC, ICTY, or basically MIG these days, and other relevant institutions like UN mechanisms for ensuring accountability in Syria, in Iraq, in Myanmar. And next to national authorities, we also work with civil society organizations. So we have permanently, on permanent invitation, 6 NGOs that regularly join the network meeting. Then we also work, of course, with Eurojust and Europol. So I would say it's sort of a platform with all the relevant stakeholders that join and connect with a view to ensure the fight against impunity.
Thank you. But may I then ask, in your role as leading this network, what options would you recommend in ensuring accountability of the Lukashenko's regime for the crimes committed in Belarus? And what support do you see that would be required in this case? I mean, are there any opportunities that you would see for your network?
Well, absolutely. I think we can learn a lot from the similar cases in the past. But first, what I heard, of course, we always say that universal jurisdiction or extraterritorial jurisdiction is not the best option, but I think it's currently the only available. So if we're looking between what the national authorities can do and potentially international tribunal or internationalized hybrid tribunal or ICC, well, those other options are not currently at our disposal. It's only what, of course, is possible to do on national level. So that's why I think it's good that we focus on what can be done now. So in order to look into possibilities for national authorities to progress this case, we always need to have in mind where we are at the moment, and what do we want to achieve for the future, either international tribunal, internationalized, or ICC, or any other that might have jurisdiction, or even national jurisdictions in the future. And that is what has been already said. It's, of course, collection of information, preservation of evidence. That's what, of course, needs to be done immediately. In that discussions or in that focus, I need to say that the Genocide Network has already been engaged with the Belarus situation. We worked, as I said, that we work also with civil society organizations. So we have facilitated a meeting between Center for Justice and Accountability and International Accountability Platform and national authorities, I think last year or year before, where we put together the relevant of course, two civil society organizations progressing this work with national authorities and basically learn from each other. First, making known to the national authorities that there are NGOs that are actively connecting this information, and of course, on the other side, to make sure that national authorities can sort of give their view on what is needed for successful case or starting an investigation in their side. So in that way, we have already been involved as a sort of facilitator, bringing together the relevant stakeholders. But I would say if we go one step further, of course, is what national authorities can do furthermore. And in that way, Lithuania already started a case some years back. That's a very good start to have sort of one authority that can bring together the relevant expertise, but also to be sort of a data leader or a facilitator for bringing information in from various sources. But in terms of any sort of success of universal jurisdiction, I would just like to highlight two cases. One is the Koblenz case. So what German authorities have conducted in relation to the crimes against humanity of widespread torture in Syria, they have conducted the trial completely remotely without having at any point access to the territory of Syria. Through open source investigation, through access to witnesses, victims, and other evidentiary material. So that's something that resulted, after, of course, a long and hard work, resulted in conviction of two individuals, two perpetrators for that crime, and sort of in judicial process highlighted the widespread systematic nature of the torture in Syria detention centers. And of course, that was done through the facilitation first of the Genocide Network, later Eurojust, and then the joint investigation team between France and Germany, later joined by Sweden as well. And the other example is what can be done on a national level is of course, coordination of work between France and Sweden in relation to the crimes of ISIS against the Yazidis. Also, important work, hard work, that is resulting in several ongoing investigations already. So in that way, I would say that national authorities, despite the fact that all of these cases might seem overwhelming for one national authority, the importance is to cooperate and coordinate with other that have either witnesses or victims or evidentiary material to sort of join forces, and then to use the resources available for national authorities. And here we have on EU level possibility to use Europol. Europol has analytical project, Core International Crimes, that allow for analysis on information. Then Eurojust has last year has received a new mandate to set up Core International Crimes evidence database that's already now fully operational. And of course, the Genocide Network that brings all the relevant stakeholders in and shares best practice, expertise, offers trainings, and so on. So despite the fact that universal jurisdiction as such is not perfect because it has only a certain amount of evidentiary material, a lot can be done through cooperation and coordination through the bodies I just mentioned. I think in that way, we can achieve a good progress. But of course, at the end of the day, we always need also a suspect, a perpetrator, a presence. Many national authorities do require a nexus with a presence, but we don't know at this moment in which national authority will have the nexus with the perpetrator. And in that way, of course, it's important to have coordinated work done, which later any jurisdiction with a perpetrator could benefit from. So it means that we will not start in 5 or 8 years from scratches when we will have a perpetrator in one jurisdiction, but we will have a very consolidated material evidence available that we will be able to later ensure accountability of one individual or many more, depending on the development of the situation in Belarus. Thank you.
Thank you. Thank you. And I turn to our final panelist, Ms. Kristina Richter, who is the advisor to Svetlana Tikhanovskaya on legal affairs, human rights, and she's also a human rights defender herself. So according to Kristina, while the ideal solution to the crisis in Belarus would be a special tribunal, so we have an answer, in Belarus, our current reality necessitates exploring alternative ways to bring Lukashenko and others to justice. The ICC, ICJ, establishing a special tribunal, and the principle of universal jurisdiction are all viable options for pursuing justice. Kristina, you have heard a number of ideas already. How do you see it?
Yeah. Okay. I definitely going to say other things, but I now hear all the people say on this conference, and I will try maybe change my speech. Yeah, I'm not a professor, I'm not a prosecutor, I'm not a judge, I'm just one of the small numbers of lawyers, Belarusian lawyers who work with this question how to hold accountable the regime and personally Lukashenko. The numbers of these lawyers less than, I think, participant in this conference room. And yeah, of course, the bringing Lukashenko and perpetrators to justice is top priorities of the OST and, of course, of our partners. We have our general and common strategy of the legal pressure, which we realized with our partner, and most of them sitting here on the first line in this conference room. And yeah, I want to notice that repression not starting in 2020. Of course, they started with before when Lukashenko gained the power in 1994. It's important to notice because we are all time when we are speaking about the crimes against humanity, we talk about the tortures which started from the tortures and other crimes, which started in 2020, but the whole history started 30 years before. And of course, what happened in 2020, it was like, you know, the all things which are boiling inside of Belarusians almost 30 years, it's going to the street. And since 2020, Lukashenko regime crossed the red lines, firstly inside the country when they beaten and tortured the people, and after that outside the country. I remember not only about the organizing migration crisis, but I noticed about the landing the Ryanair flight, and of course the facilitation of the Russian war in Ukraine. And I think it's important to notice that we have several tracks of these actions which was made by the regime. And for me, there are no better or worse ways or legal instrument to bring into justice. Of course, you say that I sometimes told about the not special, maybe hybrid tribunal, as Mr. Abraham says. That for me, the most preferred way to bring in justice to Belarus in Belarus, to establish hybrid tribunal in Belarus with participation of international justice, with the attention of international community to that, but in Belarus. This is more preferred option. But of course I understand that for this option we need to change the regime and find the political will and democratic Belarus inside Belarus. What we have now, which options? We have crime cases under the principle of universal jurisdiction. We have maybe a possibility of ICC, as Mr. Abraham today noticed about forced displaced people from Belarus to other country who have jurisdiction of the ICC. Of course, maybe a possibility to establish a special tribunal. Today we have here a discussion about the ICJ cases. Now Lithuania started this process regarding the migration crisis, but of course we have this mechanism in different conventions, in the Convention against Torture, and different conventions which are regulate these issues which regarding the landing of the Ryanair flight and that's it. And from my perspective, I think that we need to use all these mechanisms, and after that to say which horse will win in this competition, because we really don't know which will be. That's Mr. Latushka here today say that he not thinking that other mechanism will be useful or successful, but I think that we really don't know how situation will change, because most of these mechanisms which we are talking about today need to take a time. It's not about 2-1 months. And for the victims and for Belarusians, of course, the justice is delayed, means that justice is denied. And I need to notice that we are here discussing more about the accountability and justice and all these things, but we still have tortures in Belarus, we still have the crimes in Belarus, and the main goals of these mechanisms to hold them accountable, not only to bring in justice, the other additional aim is to stop the repression, because this is the strong signal to the perpetrators in Belarus. If some cases started, in some order to arrest Lukashenka and others will be in the future, it's a strong signal to these perpetrators, maybe at first step to stop this repression.
I promise that I will give you this question at the very end, asking when do we need to start and with what instruments. So yeah, this is something that we need to come.
But to finish my thing, that's, for the international community, maybe it's a good case. Of course, I understand that these thoughts about the Ukrainian now have more attention in international level, but of course, Belarusian situation is really so interesting, and for me, like a professional and as a lawyer, it's so interesting to be participant on this process. But for Belarusians, we saw this situation, and we really want to have a fast justice, and of course to stop the repression and come back home. And because, I really need to notice that's this process not only about how bringing to Lukashenko to tribunal or others. This is how to stop what now happened in Belarus. Thank you.
Thank you. And I would suggest going back to the screen, and I'm happy that initially our first panelist is finally here with us, Ms. Carmen Sheng, who is an international lawyer specializing in human rights litigation and domestic courts, and she has wide-ranging experience engaging in human rights advocacy around the world. She's currently the executive director at the Center for Justice and Accountability, where she works with survivors and their communities to seek truth, justice, and redress for crimes against humanity, war crimes, and other atrocities through litigation and collaborative case-building strategies. Ms. Sheng has said that justice and accountability are long-term and ongoing processes. And what is important in this moment is the collection and preservation of evidence, protection of witnesses, support for victims and survivors, and resources for the frontline human rights defenders who are making sure that the evidence for trials to come is captured now. So Ms. Carmen, our question then to you, looking from the U.S. experience and U.S. perspective, I hope that you have heard some of our prior discussions already and all the possibilities that are both in a way suitable but limited. What is your take on this? What is, do you think, the most appropriate approach, and what is the most appropriate option for justice? Maybe there's some US experience that you can share with us. Thank you.
Thank you so much, and thank you to all the organizers again for the invitation. My enormous apologies for joining late. I'm in California right now, and I seem to have miscalculated the time for the start of the panel. So my huge apologies. As you know, as our moderator mentioned, I'm with the Center for Justice and Accountability, and we're an international human rights organization that's based in the United States that works with communities that have been impacted by atrocity to seek truth, justice, and redress. We use strategic litigation techniques and also transitional justice approaches. And we specialize in investigating and litigating cases that involve serious human rights violations and core international crimes. I think from the US perspective, and just building on some of the things that others have said before me, one of the things I think is important is to keep in mind that sometimes the sort of universal jurisdiction work is less strategic and more opportunistic. And so that's why it's really critical to have, of course, not only your evidence that you've started gathering ahead of time, as Tish mentioned, but also in starting to identify potential venues, because that allows you to identify the potential lawyers, the local civil society organizations who can work with you to navigate the domestic justice systems. A perpetrator, may happen to be discovered in a third country or maybe transiting through, and having relationships and networks in place to move quickly is really important. And I think also similarly related to the question of venue is an issue, is an understanding of the domestic political landscape of that third country, because domestic political or foreign policy interests in pursuing universal jurisdiction cases from specific country situations may be important. And so, I'm speaking primarily around universal jurisdiction because that's really what our organization specializes in. But of course, there are many other avenues, as others have discussed today. But when it comes to universal jurisdiction, you would want to ask yourself questions of, which countries have a political interest in seeing accountability for crimes in Belarus. The existence of that political interest or prosecutorial prioritization may also make pursuing universal jurisdiction cases in that country more feasible. And then the flip side to that, of course, is also identifying which countries would be more reluctant to bring charges. And I think throughout this work, and while we are building and waiting for a universal jurisdiction case to be brought, it's critical to center victims and survivors. These are not only your potential witnesses, but they are the reason for these cases. And they can also be advocacy allies in pushing for cases to move forward. We see examples from all over the world of victims and survivors advocating for justice and putting pressure on law enforcement to take action, and that's not just in the United States. So if I may give an example of how all this played out in an example in the United States, is currently the prosecution of an individual named Michael San Correa. Mr. Correa is a suspected member of the former Gambian president, Yahya Jammeh's notorious Junglers Death Squad. And this death squad has been credibly accused of torture and extrajudicial killings during Yahya Jammeh's regime. And Mr. Correa was in the United States working as a representative of Gambia, though at some point his post was recalled and his diplomatic status had expired. However, instead of returning to Gambia, he stayed in the United States in violation of U.S. immigration laws. The Center for Justice and Accountability and other human rights organizations learned that the U.S. government was planning on simply deporting him to Gambia, where it was fairly certain he would not face justice for his crimes. And we were able to learn this information because we are a civil society organization that operates here in the United States, but we had been connected with Gambian partners far in advance of this man ever being arrested, and so we knew of their interest in seeing Gambian crimes prosecuted. And so we were able to mobilize a number of CSOs, which included international organizations that had been collecting information around crimes committed by the Jammeh regime, the Gambian organizations that have been collecting information around crimes related to the junglers specifically. And we were able to start preparing very quickly dossiers and locating witnesses in order to connect with our Department of Justice. At the same time, because there was a local CSO in the United States that had relationships with our government and had relationships with our local law enforcement, we were also able to engage in advocacy and to highlight the importance of seeing this individual prosecuted in the United States for torture instead of simply deporting him back to the Gambia, where the government had already said that they would be unable to prosecute him at that time. And so the fact that these crimes have been well documented by civil society allowed us to mobilize quickly. We found witnesses that were directly related to Carrera's crimes, including some of his victims. We were able to pull together dossiers for investigators very quickly. We were able to very quickly respond to requests for additional information from law enforcement. And our familiarity with U.S. criminal statutes also allowed us to make a very clear case for what potential charges could be brought. And so we were realistic in what we presented and advocated for. One of the things that's sometimes challenging for law enforcement is that civil society may be a little bit unrealistic or may not have a full appreciation of what sort of evidence is necessary in order to see a case pushed forward. And I think having, working closely with civil society and lawyers from the jurisdiction where a universal jurisdiction case is being advanced is really critical in understanding what is a credible case to put in front of law enforcement. Mm-hmm. And finally, I think sort of an ongoing working relationship with domestic law enforcement also really allowed us to share information easily. And our past interactions with law enforcement also gave them a reason to find the information that we shared to be credible. I think in so many cases, when you're dealing with law enforcement, your reputation really matters. And so having a reputation for being careful, for being discreet, and for conducting credible investigations is really critical.
Okay, thank you. So even though you mentioned that, yes, universal jurisdiction as an instrument is more opportunistic, less strategic, but you work with this instrument, and maybe you can, identify just very shortly for concluding, what do you think are the, main preconditions for its success with regard to the Belarusian case?
Mm-hmm. I think I fear I'm going to be repeating a lot of what's said before, but I think,
top three, several.
Top three. Evidence. I mean, cornerstone
evidence.
Is, evidence. Like documentation is the cornerstone of any legal accountability. And what I suppose I want to emphasize is really careful collection of information so that it could be ultimately shared with law enforcement. And then I think that, while you are collecting information, because sometimes information will come from open source, sometimes information will come from witnesses. And so your ability to reconnect with witnesses in the future is really important. And I guess, this is not necessarily sort of a classic precondition, but I guess I would know witnesses. I cannot overemphasize the need to protect witnesses throughout these processes. Witnesses need to be protected at the documentation stage. We need to take trauma-informed approaches to gathering evidence from them and to avoid creating other risks, such as immigration issues and addressing social needs, particularly those who have fled their country of origin. You need to protect witnesses when you are presenting them to law enforcement. In the event, they have their own exposure to criminal liability. And ensuring that their rights as witnesses are protected. And, as advocates and as lawyers, we need to also identify witness protection measures and advocating for access if necessary. Witnesses are so critical to this work. And so ensuring that they are protected, that they are not re-traumatized, that, when we engage with them, that we do everything that we can for them, because this may be a very long process. We may need them far in the future than this particular moment. Proper engagement with witnesses, I think, is an important.
Thank you, Carmen. Thank you so much. Thank you. And we will continue with the question of universal jurisdiction. And I turn to Mr. Saulius Verseckas again, and I will formulate my question in English and then in Lithuanian for you. We have heard already that Lithuania was, one of those countries, or maybe the only one, maybe you can comment, to open an investigation 2 years ago, or following the events of August 2020. So a case was opened, an investigation was opened on the basis of universal jurisdiction regarding torture and other crimes. And I would kindly like to ask the Honorable Prosecutor to maybe elaborate a little bit in general facts about this case, about the course of this case, and do we understand correctly that currently there are still no suspects of the said case? And perhaps you could comment to the participants why. I mean, maybe to an non-lawyer, it would seem very evident that we could start, with the top officials, go on to the justice. To other officials working in the justice sector, judges even. So why are there currently no suspects in the said case? And what do you think will determine in the very end the success and the failure of this case? And maybe you are aware of other similar cases in other countries, or is Lithuania a unique example in this aspect? Bendrais bruožais paprašysime pakomentuoti.
Yes, indeed. I have to say that Lithuania is so far the only country so far which is in a full-fledged criminal persecution for crimes committed in Belarus since the 2020 election. When it comes to other countries, such as Germany, for instance, they were doing their preliminary studies. Unfortunately, such studies or investigation didn't lead to opening up criminal persecution as such. So Lithuania remains the one and only country so far which is collecting evidence on the basis of the criminal code, and just as the previous speaker mentioned, we're doing so in order to have the admissible evidence and verified evidence which would later on could be used at court, which is going to investigate into this crime. It can be a national court, or it can be an international special tribunal or international criminal tribunal. And when it comes to the case itself, we're investigating into the crimes committed in Belarus. And it is quite difficult for us to gather all the relevant evidence. We have to realize two very important aspects. First of all, we need to be aware of the context of that state policies of the basically orchestrating the crimes against the Belarusians and against humanity, and the majority of such crimes are related to tortures. On the other hand, we are not working in abstract terms. We do have studies made by international organizations and bodies. We have in terms of the scale and systemic nature of such tortures. And I believe that when it comes to the scope of or the scale of the atrocities, we have more than enough of a body of evidence, and it is the case is a very strong case, in fact. But when it comes to persecuting individual on an individual basis, all those perpetrators, then we come with many more challenges. Because we need to talk about specific facts constituting the crime. And this is what we're doing at the moment. We have 44 victims in our case who have fallen victim to the repressive structures of Belarus. They were detained by police officers, they were tortured by prison supervisors. So now we have to make a causal link between the perpetrator committing all these violent acts against a specific individual, and we need to draw a very clear causal link between this perpetrator, not because of his personal problems or being in bad mood that he was acting as he was, but because such officers were behaving in the way that has been instructed by those higher in power, by the president. And therefore, we need to make a very clear causal link, and on top of that, to give contextual evidence to prove our case. Another important thing to note is that the regime is active to this very day, and it is very dangerous to the victims, to the nearest of kin, to the friends of those suspects, of the victims, of those who are still in Belarus. So you need to be aware of the need to protect the interests of the victims and of their family members, not to disclose the data too prematurely, not to make them public, because in this way the victims would fall victim twice. Primarily, and for the second time, for daring to go into this proceeding, into bringing their charges against the Belarusian regime. So until the Belarusian regime enjoys all the reins of power, we have to be very cautious in order not to put our witnesses, our victims, under second wave of torture. And our officers have collected a sufficient body of evidence allowing us to identify potential suspects from the very low rank up till the very highest rank of command. And just as Alex, prosecutor, rightly said, we cannot make the criminal persecution as a public hearing. We do need to respect a certain tactical elements, and we need to perform the actions at the time when they need to be performed by avoiding any unnecessary suffering to the victims or to their relatives. And that is the key. When it comes to administering justice, we are in a bit of a paradoxical situation. From what we are doing currently in the criminal persecution until the very goal of administering justice. And when it comes to the political level, everything is clear for politicians, what needs to be done at this very moment. So politicians are very clear about their standpoints, that there have been or there are continuous crimes against humanity in Belarus, and that politicians are very eagerly speaking in favor of International Criminal Tribunal. However, when it comes to implementing of all these political statements in practice, unfortunately, we have not much to boast of. 3 years have passed without any substantial results. We might have expected that by now there should have been a case heard by the criminal proceedings in whatever court, but we're still not clear when it is going to happen for real. If we only are going to have a national criminal persecution in Lithuania, then it would somehow undermine the importance of the scale of the crimes committed in Belarus. We would appreciate an international institute, an international structure, tribunal, to investigate it into these crimes. And I think that we do need a completely different approach in international law. Because the majority of legal instruments saying that the perpetrator state needs to acknowledge the competence of investigating into such crimes. And therefore, under the current practice, until the changeover of the Belarusian regime, we cannot expect this to happen under the current legal regime. which means that we need to change the current rules of the game. We have 95% in the General Assembly of the United Nations condemning the atrocities committed by Belarusian regime. So why not give the chance for these 95% of the General Assembly members of instituting new international instruments instead of allowing a couple of states to veto any important decisions in the General Assembly? We do need to find the solution and a mechanism how to administer justice. And I think that it's time for us, it's high time to go to actions actions speak louder than words, basically. Thank you very much for your intervention.
That with regard to the case in Lithuania, the investigation that is going on, we can look forward to results in the upcoming year, at least. I know it's not, today, it's not next month, perhaps, but it's something that is possible of being conceptualized, so something we can already grasp. So apart from the restrictions that have already been mentioned, and Isabel, I turn to you, we also know that there are other preclusions and restrictions, such as the functional and personal immunities of the leaders of the regime. And as you do research, as you conduct your research on the novel approaches towards international law, and I come back to this, in your opinion, do you think it would be reasonable to consider that, taking into account the unique position of Lukashenka, and I have in mind his non-recognition by the international community as the lawfully elected president of Belarus, maybe we could, raise the issue of immunities. Perhaps they should not extend to him, and maybe others, beyond. We would really appreciate your thoughts on the question of immunities and how, maybe other instruments that could make this, that could somehow lessen the number of restrictions and allow for a more effective process. Thank you.
Thank you very much for this question. So I believe it actually also ties in with the idea that was raised earlier on an alternative new government being recognized and possibly referring the situation to the ICC. So that's a similar issue right there, because I believe both in terms of the question of absolute immunity of the Troika, so head of state, head of government, and the foreign minister, and the question who is representing the state vis-a-vis the ICC or in the United Nations, for example. The first question that has to be answered is the one who is recognized as the head of state. And in this regard, recognition, to be precise here, is only a declaratory act. So what is decisive is the status, who is the government. But of course, what national courts do is usually look at the recognition statements of their respective states in this regard to determine who enjoys absolute immunity. And what I found in my research throughout the last years is that for the last century, more or less, effective control of the territory and the population has been decisive, but there have been changes. So there have been cases, for example, where democratic elections took place, and then after these democratic elections, the incumbent government was not willing to hand over power to the democratically elected new government, and the international community then recognized this democratic government, though it was, for example, based in exile. Now, when we apply this to the case of the Lukashenka regime, though, I believe that at least the vast majority of states have not seen this withdrawal of recognition through. And I think that this is what, for example, distinguishes this case from the Myanmar precedent, because there the new coup government was not recognized at all. And so here, when we look at the recognition statements, for example, by the EU member states, what they were actually all condemning was the lack of democratic legitimacy. but hardly any statements explicitly state that he is not recognized as the head of state anymore. And this is the discrepancy that I see here. So therefore, I believe that there was actually no withdrawal, possibly because he is still in effective control, possibly also because recognition is, of course, always a political or highly politicized act. I mean, it's not strictly speaking political because it's regulated by international law. And this is also why I believe, also based on my research, that state could legally withdraw recognition based on an argument to be made on internal self-determination of the people in Belarus, who actually exercises internal self-determination in the vote. But also, I mean, we've heard on 2 panels this morning that jus cogens norms and erga omnes obligations are being violated in Belarus on a continuous basis, and that this incumbent regime is only staying in power because of these violations. So I think that there's also an argument to be made that countermeasures could be taken to withdraw this recognition. But as long as this has not taken place, I believe that Lukashenka still enjoys absolute immunity, at least in front of the states that do not withdraw recognition, and that it would probably also be difficult to see a referral by an oppositional government unless it's formally recognized.
Mm-hmm. Thank you. Marike, what are your thoughts on this? And then maybe you can continue a bit more, expand a bit more on the possibilities, once again, of accountability before the European Criminal Court.
Thank you. Thank you so much. Such interesting remarks, and I would love to read more about your research. And I fully agree. However, I do think that we are in a time where international law, international criminal law is being pushed. And this Ukraine situation is, of course, terrible. And at the same time, it's also making, I think, some particularly Western states think again about the precedents they created in the past. And particularly, for instance, now of all these discussions around the crime of aggression tribunal, where particularly France and the United Kingdom and of course the United States were very much the ones that made the ICC so limited for the crime of aggression that right now for Ukraine it doesn't apply. And I think right now is a time to look at the situation of Ukraine and to look at the situation of Belarus and really sort of show the importance of the progressive development of international law. And it doesn't mean that it's going to become, you know, like if you're going to try and push the boundaries a little bit, that it wouldn't be contested by a lot of us, right, law professors, that will say, you know, this is not in line with current international law, international criminal law, but that also happened with Nuremberg, right? I wrote my PhD on the law and politics of the crime of aggression. If you look, you know, doctrinally to what happened in Nuremberg, it was really retroactive application of international criminal law. Hardly anyone would doubt it. And at the same time, hardly anyone doubts that Nuremberg was the foundation of international criminal law. So, you know, there's some space there for, well, the gray. I'm wearing appropriately gray. So with immunity, head of state immunity, I'm not saying it's an easy argument. I know all the arguments. We all know the arguments. However, one thing that we've been sort of debating over these past days as well here in Lithuania on the crime of aggression tribunal is, and it might also apply to this, what if you create something separate from the question of like withdrawing, surpassing the head of state immunity? So, you know, what about sort of looking, so for the crime of aggression tribunal, but I think in a similar way, looking at whatever a coalition of the willing is in establishing an institution and separately trying to get some sort of acknowledgement by the UN General Assembly that those entities, you know, the Belarusian, whatever you call it, the Ukrainian aggression, whatever you call it, that it represents the international community, that it's respected as acting on behalf of the international community, and in that sense is truly international. Would that allow prosecutors later on to make the argument to say, you know what, in this situation, the General Assembly says it's truly international, or it says it's on behalf of the international criminal community,
maybe we just give it a try. I'm not saying it's an easy argument to make. I'm just saying that maybe it's not an impossible argument, and actually maybe it's the right argument to make. So that's for one. Like let's think of the era we are in, the developments we see, and also think a little bit outside of the box. Up until now, we always connect the establishment of a tribunal to the immunity question. It doesn't necessarily have to be. So it can also be whatever it is, created by whomever it is, with some sort of an like respecting or whatever resolution, recognizing. And then in that sense, also like to the International Criminal Court, because you also asked me what the International Criminal Court can do. Like the International Criminal Court is ideal, of course, because it doesn't respect these immunities. Its own appeals chamber has said so. And so in that sense, like it would be great. However, we already talked about the jurisdiction of the International Criminal Court is very limited. Because Belarus is not a state party, obviously there's not going to be any accession to the Rome Statute right now. However, because of the Bangladesh precedent, Myanmar-Bangladesh precedent, there might be the ability to have jurisdiction over the crime of persecution, forcible deportation, forcible transfer, and who knows what else. And of course, there's also now the discussions on, you know, maybe it's good for Belarus to be part of those cases that the ICC hopefully is going to do for the child deportation. And there's also, you know, the situation, maybe Lukashenka can also be tried before some crime of aggression tribunal. And I think that all of that is very important and very important to try and get all of these institutions that exist to do that. And I fully agree with also the chair of the Genocide Network and prosecutor that the universal jurisdiction developments are another symbol of this pushing, you know, what we used to not be able to do and we are doing now. And I think the developments there here in Europe, under Eurojust, in the Genocide Network are phenomenal and really the future of international criminal justice. But they are also limited, and therefore in the sense of who you can reach, because the ICC will only focus on those in the top. Universal jurisdiction, only those that can grasp. The ICC, other cases, maybe just a little bit. And so, therefore, the creative thinking is very important. And I think for the creative thinking, all options on the table, also the People's Tribunal that Arun said, I think is really important. And for that thinking, and that's my last remark, I think the most important thing is to think about what is it for? What is the actual goal that we're trying to achieve? And in the Netherlands, we recently had the MH17 case. The people that stood trial were not present. It was, you know, 300 people dying, and then you had some in absentia rulings, and it really was sensed as justice. And the reason that it was sensed, felt by the next of kin as justice is because the prosecution did a phenomenal job in communicating expectations and what justice could be for them. And that was acknowledgement, truth-telling, fighting disinformation, but also, and I think that is key for Belarus, it's not just about getting the prosecutions now, which of course you want, or the prosecutions in the next decades, which of course we hope, but it's also about the history books in the future that, you know, not like you have here in Lithuania, that you still have never really got acknowledged what you underwent, but that in the history books there can be a reference to whatever authoritative judgment, whether that has jurisdiction or is a people's tribunal, but that it's authoritative, and so that not 100 years from now people are still saying, remember what happened, no, that didn't happen, you have something on paper. And so that managing expectations that you're not going to have all the justice you want, that it's not going to be perfect, and at the same time trying whatever you can so that you can communicate that justice, the acknowledgement for the current generations and the future generations, I think key what we're trying to do here.
Thank you, Maria. Thank you for the constructive optimism. And I turn to Professor Whitening, and we're getting to the, you know, very interesting part.
No pressure. No pressure.
Just wait. No, so we have heard about what is going on, because there are, yes, investigations going on. There are ideas being brought up based on your experience in Kosovo. What opportunities do you see? Similarities, you said, not differences. What are the similarities, opportunities? What is your recipe if you had to put one up on the table?
So I need to produce a recipe. Okay. Well, just to draw a little bit on what Marika was saying, I think I'm going to push back a little bit on the idea of creativity. I think what's interesting about the field of international criminal law is that in our lifetimes, since 1993, there have been extraordinary leaps and bounds and developments in the field of international criminal law. Developments that nobody would have predicted before they happened. At the same time, it's important to remember that there's a lot of caution in those developments, and that states are fundamentally cautious and conservative in the way they develop these institutions and these approaches. The International Criminal Court, the most important institutional development in our lifetimes in this field, is by design a very weak and narrow institution, right? And then on top of that, we also have to remember that the rule of law in our lifetimes has also been under increasing threat and has been increasingly politicized and weaponized. And so when you put those things together, I get a little anxious when I hear ideas about bending and stretching the criminal law in the international sphere, because first of all, I think I'm skeptical that states are going to bend very much. And I'm also nervous about bending, because if you bend the law for your purposes, you have to think about who else is going to take advantage of that in the future. What authoritarian leader is going to take advantage of that creativity and become themselves creative in the imposition of criminal law, which is, let's remember, criminal law, we're talking about the most severe sanction that the state can, or that international institutions can impose on people in terms of legitimately, right? So, yeah, but states, if there's one thing that states get nervous about, is immunities, right?
I wouldn't argue criminal.
Well, I thought we were talking about, I'm only talking about criminal law. No, but immunity from criminal law, from criminal prosecution.
Criminal law, criminal norms, they need to be protected.
Yeah, and states want immunities to be protected. I don't know. So on the one hand, so I'm constantly torn here. And on the one hand, we have to look for opportunities to jump the law forward. But I think that primarily we have to think about how we operate within the sandbox that is available to us, and think about how we're going to succeed with the tools that are there. And here, to answer your question, well, Kosovo, I think that if there's something that can be positively drawn from the Kosovo example, is that after many years, there is strong efforts and commitment to accountability. So, we are prosecuting, we're at the moment prosecuting, and I'm talking in my personal capacity, I can't comment on the court, but don't please, this is not official, not saying anything, I'm just stating the facts. With all these caveats, we are prosecuting the president of Kosovo, former president, because he resigned when we arrested him, and several other leaders for crimes committed more than 20 years ago, alleged crimes, because we're in the middle of trial, more than 20 years ago, and with strong support from the European Union, from the government of Kosovo. So I think if there's a lesson to be learned here, and a way to think about the work that we need to do today, is that this is a long game. You have to think about the long game. And I know that several people have said, well, we can't wait for the long game because there are crimes being committed today, and we need to try to stop that. I appreciate that. But if we could do it today, sign me up. I'd be the first to be there. But we have to, in this business, think about how to preserve the evidence, how to build the institutions, how to build the support for the long game. And maybe it'll be in 6 months, maybe it'll be in a year, maybe it'll be in 5 years, 10 years, and maybe my children will be the ones prosecuting at these courts.
Thank you. So, in your opinion, our main focus should be on, in several words?
It should be on, and again, this is what I said a year ago with respect to aggression. It should be on. It's always the same message. You can just tape it, and next year you can just play the tape. It's this. The message is capture and preserve the evidence in real time. As a prosecutor, I'm always going back in time. I'm always trying to get trying to go back in time 5 years, 10 years, and trying to reconstitute what happened, trying to collect evidence that's no longer available, trying to refresh people's memories. And so as a prosecutor, I wish that people had collected and preserved the evidence to a criminal law standard. So what I recommend is that CSOs and prosecutors work together to develop processes, procedures, standards, mechanisms to collect and preserve the evidence. So there's the answer. There's the recipe.
Thank you, and actually, yes, also resembles the advice we received from overseas. So we have an idea that is, one that connects us in a way, right, in the panel. Arif, we're coming back to you, and please, if you can, you presented very interestingly the idea of a special tribunal, people's tribunal. Could you comment a little bit on how you would see, its mode, its jurisdiction, composition, mode of operation, functioning? What is a successful model and one that would be suitable with respect to Lukashenko's regime?
Sure, thank you. Marike got some pushback from Alex, and I'm going to push back on Alex's comments in turn. And maybe I'll try and square the circle here. I think Alex is right that, of course, there are some principles of international law, like immunities, which are there for good reason. We don't want a situation where you can't have diplomatic relations between states because they're suddenly putting all people's officials in prisons for all sorts of reasons. So, there are some good reasons for some of the international rules and how they're prescribed. I think where I'll differ and distinguish is, of course, that we have now a whole plethora, volumes of international criminal law, international human rights law, which is binding on states. So, we are talking here about crimes against humanity. There isn't any contention about what these crimes against humanity are. We know they're peremptory norms. We know that there are erga omnes parties obligations. That means all states are bound and must implement these rules and regulations and must give them force in their domestic legislation. So we're really, in this context, we're talking about enforcement, and we simply do not have the institutions willing or the states willing or able to enforce what is accepted to be binding international law. So in respect of the People's Tribunals, there are two kind of, I say you've got to go back to first principles. The first principle is that the law is not synonymous with justice. We know that the law can be incredibly cruel and unjust. So we've got the laws, so there's no contention about that. Second, the whole point of international law and the states which are meant to enforce it is predicated largely on the fact that states are meant to be democratic. And who are states ultimately accountable to? They're accountable to their citizens. And that is what forms the basis of the idea of a people's tribunal, is that it's the citizens taking the initiative to enforce the law, which is their law, which the states are meant to abide by and also be bound vis-a-vis their citizens. So that is the kind of basic principles upon which a citizens' tribunal, people's tribunal is founded. And of course, they can be founded in many different ways. They can be completely inept and don't follow any international precedent, and there are some examples of that. Or you can say that we're going to create we're going to create one that's bound by international best practice. So ensure a fair trial. So for instance, you'd invite the Belarusian state to come and take part. If there are anybody in respect of which there are allegations, you'll send them letters to say, you're very welcome to come and submit to the jurisdiction of this court, which in theory has no jurisdiction. It has no binding force of international law. It cannot enforce its judgments, but its authority is in the fact that it's independent, impartial, constituted by concerned citizens, appointed preferably through fair competition with judges and prosecutors and people who staffed also by an independent body who are not activists. And if it can produce statutes, rules of procedures in the same way you would have for an international tribunal, and for all intents and purposes, it would be an international tribunal just without any formal authority. And of course, its authority is in the fact that if its processes are fair, if it presents both sides of the evidence and allegations, if counsel is fair during their proceedings and they present the case to a panel and the panel make a judgment, the judgment, the evidence, the decision, the reasoning will be for public scrutiny by anybody who wishes to see it. And of course, the force of that is that if it's persuasive, then of course that evidence, the decision, the reasoning can be used in the future by anybody, by political states for sanctioning purposes, by future courts, domestic courts under universal jurisdiction. They will have all the underlying evidence, of course protected to ensure no witnesses are put in harm's way. And then ultimately it would be a kind of interim step to what would hopefully be one day a future tribunal. And as Marika powerfully put, this is about truth-telling and narrative changing in the absence of any other available option. And you'd hope that one day a formal body would do it, but there's no guarantee of that. And we know that today, where there are calls for tribunals in the case of Syria, it's not happened. There's been calls for a tribunal in North Korea for the good part of 5 decades, it's not happened. South Korea, there's been calls for a tribunal in respect of Japanese crimes. I mean, we can go on, and the list of failed accountability efforts are endless. So I think, on a hopeful note, I think we don't just talk about hope, but we try and make it active by becoming a hope, so to speak, by taking the initiative.
Thank you. Mr. Richter, maybe you can comment on the idea suggested. Do you see this as a possibility in Belarus in any foreseeable future? And if not, what are the alternatives?
I have a dream. That's what we'll see. You know, that's after Mr. General Prosecutor speech notes, I think that's a little bit, or maybe a strong frustrated of the crisis of international law, because I understand that world is not ready to have a deal with dictators. It's really so hard to bring to justice people like that and all perpetrators like that. But after that, I sit in with Marika here, and I saw empowering of the optimism of her. That's we need to think about the holding accountable out of the box, and maybe sometimes changing the not the international principles. Of course, the principles need to be unstable, but we need to change the practice. And we all time thinking about the Belarus in this side, that's how to repeat some practice which we have from the other historical cases or from the other countries, and all time thinking about the Myanmar, Cambodia, and other countries, and the experience of these countries. But I understand that's maybe we will be the case and somehow and some when people say that maybe we repeat something like happened in Belarus. I mean, that's not the repression. We repeat the experience to bring into the justice. As I say, that I really believe that justice, true justice for Belarusians, can be at home in Belarus. I think that there is only one way to how Belarusians will feel comfortable and feel, that's so. That all process of accountability is succeeds when we have these processes in Belarus. I think only this way, but of course I understand that now we need to have all these mechanisms. This is quite nice idea to establish maybe some people tribunal, and I of course communicate with you about this more and get more details and maybe to create some ideas. But now our common strategy of democratic forces about the legal pressures is a different ways to how to start procedures in ICC, how to establish a special tribunal, how to start more cases under the universal jurisdiction in different countries. Also, I want to notice that not only the Lithuania started the case and investigation, as well Poland started, but they not share this information and this information about the investigation process. And yeah, we have a few cases which we are trying to start somewhere, for example, in Germany. I know that someone was prepared but not was applied in Estonia and other countries. But yeah, this is the process of collecting data, finding the victims, finding the lawyers in different countries, and finding the political will of these countries. This is not quite easy process. But yeah, I think that if we make all these steps, yeah, we can find the justice for Belarus.
Thank you so much to all the esteemed and colleagues, panelists. And our time is up. We have been given an extra 15 minutes, so we are just 5 minutes past the time. Once again, thank you for coming. Thank you for participating under the circumstances that are today. My only wish as a moderator is that any of these ideas, or a bit of all of them, that they start to materialize, maybe in a year, as once again with the last conference on the tribunal for Putin's regime, we saw that there were significant developments that maybe could not have been imagined when the initial conversations were started and when they took place. So this is my wish for us, that in a year we will see development, in one of the directions, in several, but we hope for development. Thank you once again, and thank you.
Distinguished guests, all conference participants, may I address you, being honored to moderate this fourth session of this international conference. So much have been said, so many deep insights on the repressions of the Lukashenko's regime and the crimes that amount to crimes against humanity, and so many possible ways in seeking justice. But you know, there is still one element, one detail of a puzzle that we still lack, and this is the so-called migration crisis. Other words, it's forced migration, or as it was put by the European Union, one of those declarations that we a little bit criticized for, you know, being not legally binding, and we have so many of them. So instrumentalism, orchestrated instrumentalism. So we had the migrant groups escorted by armed Belarus forces. And so this is the cynicism of Belarus regime, that by stirring up crisis at European Union external borders, it is trying to distract attention from the situation in the Belarus country, where brutal repressions and human rights violations are continuing, and as we have heard, even worsening. And so the European Union strongly condemned the Lukashenko regime for deliberately putting people's rights and well-being in danger. And not only does this breach international law, also disregards fundamental human rights. Such inhuman action shall call for strong international reaction and cooperation in order to hold Belarusian regime responsible. And you know, the element that was still missing in our discussion today, so-called hybrid attack, orchestrated instrumentalism, forced migration. So this mostly affected 3 states. And that is why, not accidentally, my dear guest speakers in this panel are representing Poland, Latvia, and Lithuania. And you know, we all share the same experience. I mean that we were pushed in the corner between 2 things that should be balanced, but perhaps they were not even possible to be balanced. So the full protection of your human rights standards, and of course the protection of state sovereignty, of the security of our countries. And so I'm very glad today to introduce my guest speakers of this panel, number 4. Our task is to deal with issues about the establishment of international obligations of Belarus applicable to the situation of sharply increased irregular entries into Lithuania, determining direct involvement of Belarusian institutions, initiation and maintenance of such situation in Lithuanian ways for ensuring responsibility as breaches of international law. So, dear colleagues, I will invite my small and cozy panel to proceed in the following way. So first of all, I will give the floor to Mr. Alexander Gubrinovich, who is from the University of Warsaw of Poland. And then another participant is Mr. Vitis Jurkonis. It's from Freedom House. So much contributed to the free speech, to the research and protection of human rights, including in Belarus. We are much honored to be joined by Excellency Ambassador at Large, the Three Seas Initiative, Mr. Edgars Bonars, Latvia, and the panelists which will share insights which I believe are similar to Latvia's and also Poland's in in this topic. So it's the Vice Minister and also my colleague at Vilnius University. It's Gabija Grigaitė-Daugirde. So first of all, I turn to Professor Alexander Gobrinovich. You know, so much has been said, and we heard at least twice, The Hague is waiting for you, yes? So this was addressed to not only to Putin, to Lukashenka. But you know, at The Hague we have not a single court. There's also the Peace Palace, yes? The court that is dealing with interstate petitions. And when we have state, we speak about state responsibility because claim responsibility and realize responsibility, you know, it's the fundamental element of statehood. When we speak about a true state which has face, I'm not sure about Belarus. It could be a good example for students, you know, studying recognition, statehood, international law, but it's a very bad one when we speak about the true country that should be in international relations. Yes, so, Belarus is not a safe third country when we speak about asylum, yes, when we speak about being a black hole of Belarus, you know, not participating in majority of conventions. And still, this should not allow it to escape justice. And perhaps we still have some room, you know, some possibilities to speak not merely of the responsibility of those for crimes against humanity, but also of the responsibility of state. So, dear professor, you were so kind, I know, to prepare even the presentation for us. So could you please proceed with, you know, the legal background of the state responsibility, perhaps with a focus on those elements or grounds that could fit in this, unique but still state of Belarus. Thank you so much.
Thanks a lot for your introductory note about me, about the topic. I take the liberty to express my gratitude for your kind invitation. I'm privileged to be for the second time here, so my gratitude is really, really big, believe me. If it is about the topic, yes, exactly. We must change the area of our interests a bit because, as you know very well, in the international law, there is a division line between the responsibility of individual, which is basically a criminal one, and the responsibility of states. The rules are not the same. The provisions regulating state responsibility are codified in articles on the responsibility of states for international wrongful act, non-legally binding resolution adopted in 2001. And this document, of course, I'm not here to reintroduce it because I'm absolutely persuaded that you know this document very well, but just to short reminders. First of all, it is generally accepted in the literature that the purpose of state responsibility as an institution of international law is twofold. Now, first of all, it determines the circumstances under which a breach of international law occurs, and secondly, it determines the legal consequences of the violation. Plus, please don't forget that a state is maybe held responsible for every wrongful act. This is exactly what flows out from this resolution, which, by the way, is considered to mirror in lion's share the international customary law. And second, according to Article 2, there is an international wrongful act of a state when conduct consisting of an action or omission is attributable to the state under international law and constitutes a breach of an international obligation of that state. In practical terms, it is worth to underline one more time that whenever you think about the state responsibility, you don't need to think about the mens rea. You don't need to think about guilt. You don't need to think even about damage. because in fact two elements are necessary to establish the state responsibility. The fact that the mere fact breaking a norm of an international law, no matter from what kind of source this norm takes its origins, and the mere fact that this breach may be attributed to a particular state. Point. And of course, against this backdrop, the question arises, and this is the last issue about the responsibility as an institution of the international law. State is responsible for what? And here we know very well for organs, no matter if these are organs of legislative, executive, judiciary character, are they territorial or self-governmental, no matter, state is, at the end of the day, responsible for every entity which has a power to execute some competences, even if this institution is of private character sometimes. And finally, the question: is it possible to imagine a situation where a state is responsible for the acts of private individuals? On a narrow basis, yes. Article 8 is very clear at the point. Following the line of the doctrine in Nicaragua's case, this provision says that if the group of individuals, private individuals, acts under the instruction or under direction or control, then of course a state may also be responsible. Now the problem. The problem is that I must place my considerations in the context of migration crisis, and now we have the problem really complicated, because, you know, the problem is that according to many experts, the term migration crisis is inappropriate, should not be even used, not only by lawyers, but even by politicians. Why? Simply because there is a fear among politologists, psychologists, and other experts, perhaps non-legal experts, but rather the experts in academia focusing on other topics, that if you link the word migration and the word crisis, the general public will start to think that at the root of the problem is migration, and this argument very often may be abused in a manipulative manner by anti-democratic forces, simply put it, okay? So this is why when I started to make a research, it appears very clearly that the term migration crisis is avoided, and frankly speaking, I cannot indicate but just one legally binding act where the term migration crisis is used. So we are living in a schizophrenic situation where migration crisis is present everywhere. Politicians say about migration crisis. Sometimes certain documents published by the UN homepages also use this term. But when you look at the origins, when may I find some information about the legal context of this concept, there is no concept at all, simply because there is. So if you truly want to understand why, not only because there is a fear that anti-democratic forces may abuse this term to its own purposes, but also because it is terribly difficult to encompass with such a ambiguous term, such complicated story like the migration crisis. Look, for the functional or operational purpose, the International Organization for Migration, which is basically one of the agencies of the UN, submitted that migration crisis can generate population movement within or outside the borders of a country. This may occur suddenly or gradually and is affected by migratory movements prior to the crisis, as well as changes in subsequent migration patterns. The term migration crisis describes complex and general large-scale migration flows, as well as the mobility patterns caused by a crisis that often lead to considerable vulnerabilities for affected people and communities and pose serious migration management challenges in the longer term. Okay, it is clear that this definition is non-legal, is descriptive in its character, and even if it may be used for the purpose of this lecture as a point of reference, please don't attach too big importance to it. Simply because it is absolutely clear that if you think about the migration crisis, you need to address not only the effects of this crisis, that is, for example, the problem at the borders, for example, but you need to also address the real causes of the migration, that is, the problem of poor people who are very often living in least developing countries are simply coerced by factual circumstances to leave the country to save their lives. It is quite interesting against this backdrop to observe that, for example, such experts like Lukas Gutentag also refused the place in the legal academia for this term, and he said, according to his opinion, we can say only something about the border crisis, but border crisis in this term is understood as a failure of the government to administrate the checkpoints properly, and it was basically the allegation directed against Trump and this famous story where Trump suddenly strengthened control at the borders, telling to the general public that the migration is a threat. If it is about Lukashenka and recent contribution, there is another term which is absolutely not the one which should be mingled with the migration crisis. I would say that it's perhaps one of the facets of the migration crisis, instrumentalization of migrants. And here it is quite interesting to observe that there is a document, there is a proposition of regulation submitted 2 years ago by the European Union. However, at this stage of development, this regulation has not been adopted yet, or won't be adopted never, I don't know. And here the instrumentalization of migrants was defined as a situation where a third country instigates irregular migratory flows into the Union by actively encouraging or facilitating the movement of third country nationals to the external borders, onto or from within its territory, and then onwards to those external borders where such actions are indicative of an intention of a third country to destabilize the Union or a member state, where the nature of such action is liable to put at risk essential state functions, including its territorial integrity, the maintenance of law and order, or the safeguard of its national security. It is the first signal that, to my best knowledge, where the European Union submitted a proposition of regulation seeking to bridge the gap between the core values, I mean human rights and refugee law, and on the other hand to address the problem of security, which emerges at the moment when, in fact, as it is the case of the Belarusian dictator Lukashenka, the migratory flux is used as a tool to destabilize the domestic situation in a member state or in the European Union as such. But we must come to the conclusion after this survey that there is no one term or one definition for migration crisis. Second, and perhaps even more importantly, migration crisis, it is a phenomenon which is widespread from the country of origins until the country where the migrants arrive and supposedly are to be accepted if the provisions of or standards of international law are met. It is quite interesting, however, to observe that very often one of the cause of the migration is the mass violation of international law. It is something which is quite astonishing to observe, that whenever you take the books on migration, you can find, and the author or authoress discusses the origins of the migration. They say quite a lot of things about the poor governments, they say quite about poverty, corruption, but very often they say that it is also one of the leading causes of the migration, the lack of observance of human rights standards and mass violation of the international law. On the other hand, the effects of non-controlled migration flow also must be somewhat encompassed, included in this migration crisis, if somebody wants to use such a term. So, for example, the effects concerning the reaction of transit and final destination state that are to handle the increased number of cases of illegal or illegal attempts to enter their respective territory. And now, coming back to our problem. Ladies and gentlemen, just because there is no a definition of migrational crisis, no surprise then that what is in common parlance called migratory crisis must be handled in accordance with and through the lens of the existing rules of the international law. And it is absolutely clear for anybody that international law, in fact, regulates some causes of the forced migration and some effects, but is partial, is selective, okay? It is not possible to say that the causes of forced migration are fully covered by the existing rule of the international law. It is not also possible to say that all failures of organs to handle the effects of migration are covered, okay? And from the theory, the last point, and just I switched to, and we are coming to the Belarus. It is quite interesting to observe that the country of origins, the country of transit, the country of final destination may be sanctioned for the breaches of sometimes the same rules of the international law. Consider, for example, the prohibition of torture. The torture may be the cause of the migration. The torture may be inflicted during the transit of a victim, and finally, the torture may take place at the country being the final destination of a migrant, asylum seeker, or refugee. Now, it is generally accepted that this crisis, which took place starting from 2020, it was artificially engineered, and we can say that, in fact, Belarus dictator Lukashenka instrumentalized the migration flow to achieve certain political purpose. This is the list what you can see here, of the most commonly quoted treaties which were broken by Belarus by instrumentalizing the migration. Starting with UN Charter, there is a strong argument to tell you that even the prohibition of use of force was broken. I still remember the screenshots or the films you can find in the movie or in the media. The group of Belarusian border guards transgressing the border and entering without any prior authorization the territory of Lithuania and the territory of Poland. These are facts, ladies and gentlemen, okay? Principle of non-intervention, as it is laid down in the not only in the charter but also in declaration. Agreement between Poland and Belarus on good neighborliness and friendly cooperation, as signed in June 23, 1992. Here, the story is of particular interest simply because we can eventually discuss if by breaking this article, the Belarus broke the rules of territorial integrity or just the border inviolability, because both terms are used in this treaty. I think that we don't need to dwell, because it is my understanding that the border inviolability is a function of a more general principle, territorial integrity. But perhaps I'm mistaken. The same is true treaty between treaty between Belarus, good neighborliness and neighbor lines and cooperation. Treaty between Latvia and Belarus on border control post. Again, the story is about the entry of Belarusian border guards without prior authorization, even if it was required by this treaty. What about Geneva Convention on refugees? Again, here we have the story is a bit not so clear-cut, but first of all, we should never forget that if somebody arrives on the territory of Belarus, it is my understanding that Belarus is under duty to launch the procedure to check if a person is an asylum seeker or not. And it is not possible, well, they say that they did something. Assume that they acted in accordance with the Geneva standard, but if they had acted in accordance with the Geneva standard, again, another question arises: why the Lukashenka's regime forcibly expelled those people against a very clear rule of Article 32 of the Geneva Convention? Of course, we were talking about the prohibition of torture. You know very well that tortures are prohibited by the Convention Against Torture, and the same is true of some other instrument. Finally, we have the protocol to prevent and suppress and punish trafficking in persons, especially women and children, and this protocol against smuggling of migrants by land and sea. I stop here because I hope that Mrs. Vice Minister has more on the issue. Just one observation. This paragraph I choose not by hazard, but this is the paragraph which probably could serve as a basis to bring the Belarus responsible for the breach of the rules of this protocol by luring the people on the territory of Belarus. Now, the problem. The problem is that to what extent Belarus was successful in changing our understanding of the migration problems. To a degree, he was successful because, as Mrs. Chairperson correctly observed, even the politicians of the top of the European Union, Ursula von der Leyen, started to use the language which is close to the military one. So, for example, we could say that the action of Lukashenka is a hybrid attack to destabilize Europe, okay? But again, the problem is there any legally binding definition of hybrid attack? I tried to establish what the militarians, NATO circles understand under this term, and here is again a cacophony, so please relieve me from the duty to enter another troubling waters, because I have nothing to communicate, okay? We should never forget that although Henri Michel, Charles Michel, the president of the European Union, also was using the similar words, okay, similar terms. Why? Simply because I think that it was the natural or even psychological reaction for the fact that the instrumentalization of migration, as it was launched by the Belarusian government, led to the many breaches of fundamental norms of the international order. And that's why, in a sort of reaction, the issue of migratory flux was suddenly begin to be perceived as a rather threat to the security. By the way, this element of the security has always been present in the narrative about the refugee law. If you look at the Geneva Convention, it is absolutely clear that you can find provisions inside seeking to protect the national interests of state. But suddenly, by this instrumentalization, the tonation and the discussion achieved a completely different tone, okay? So, and what about the countries and what are the results? The results are, as correctly Mr. Chairperson observed, the pressure upon our states neighboring with Belarus started also to increase. And it is not a secret that the Polish authorities, Latvian authorities perhaps also, Lithuanian authorities, were suddenly coerced to dance on the very thin line, because on the one hand we were under duty to observe the refugee law, the European Convention of Human Rights, the European Union legislation concerning the migration, and on the other hand, it was absolutely clear that some fundamental norms were broken by Belarus. And of course, all this situation led to the conundrum, where it is true. Sorry to say publicly, but it is. But I must say. The strategy of so-called pushbacks was used by not only by Polish border guards, Lithuanian border guards, Latvian, I don't know, but also by Frontex functionaries. It was the logic consequence of a new situation which was artificially created by the dictator. Now, the problem. Is it possible to say that Lukashenka was efficient to a degree? In political terms, he was efficient simply because suddenly the neighboring state was blamed, so to speak, by the breaches of the human rights and refugee law. Point. On the other hand, the situation about the remedies is quite difficult, because on the one hand, you can find the resolutions discussing where the Security Council considered migration flows as intertwined with the problem of maintenance of peace. And if you remember the first time where the human rights were considered as a valid ground to use the military force by the Security Council, it was exactly on the basis of the migration flow. On the other hand, it is absolutely clear that in the situation like this, we are not allowed to use military force. We are not allowed to use military force because to use military force, the use military force is prohibited by the Charter. It is rather the realm of the Security Council competences. I don't need to dwell about the situation in the Security Council, so we can omit this paragraph. If it is about the Article 51 and self-defense, well, Lukashenka was smart enough to understand that it is not in his business to push the situation beyond the threshold of the armed attack in the sense of the Article 51. Perhaps this is why the situation of our countries is really awkward, because on the other hand, just because Lukashenka stopped before pushing the migration instrumentalization to the extreme, it is not possible to say that we can expect our domestic concerns will be well understood by the European Union. But on the other hand, the European Union maintained all the way the case line concerning the status of refugees and human rights protection of migrants. Let me be very clear at the point. One of the most important and very interesting cases handled by the Court of Justice of the European Union was the famous case MA versus Valstybės sienos apsaugos tarnyba, where the problem was. The problem was that because of the migratory flux, completely uncontrolled and instrumentalization of migration, Lithuania introduced a state of emergency, and suddenly it appeared that the lodging of application for asylum was no longer possible, or it was at least very difficult. And this fact triggered the reaction of the European Union institution, and Lithuania lost its case. Please don't forget, Lithuania is absolutely not an isolated case. My native Poland is exactly in the same situation. We have a lot of cases pending before the Court of Justice of the European Union or before the European Court of Human Rights, and I don't expect to see its winning. Okay. So what these countries can do against this? Well, first of all, of course, very good idea to go to the to the International Court of Justice. Yes, this emerging case based upon the protocol 200,000 protocol, I fully back. So the concept that Lithuania would like to wishes to demand cessation and non-repetition plus compensation is a very good one. The problem: what if Lukashenka, seeing that he could lose, starts to withdraw from one treaty to another, or to paralyze, or to withdraw the consent for the jurisdiction of Belarus to the Court of Justice of the European Union? I don't know. Perhaps it will be possible to discuss. And the conclusion. The conclusion might be summarized as follows. As there is no clear definition of migration crisis, this term, coupled with some other terms being in common parlance, hybrid attack or hybrid aggression, whatever, hybrid operation, etc., did not influence the European Union policy and European Union legislation in a decisive manner. What is on the table is, to my best knowledge, rather a set of modification which seems to maintain the traditional understanding of the values upon which the European Union is based. There is no move, to my best knowledge, or any attempts to take our concerns seriously. The reaction. I must finish. The last thing. In fact, when you look at about migration crisis, please don't forget the causes of this crisis are very often 100 miles from here away, and we should not forget that perhaps state responsibility, it is only institution which may be invoked only on some occasion. Because if you truly want to avoid instrumentalization of migration by the third countries, we need to address, as a European Union this time, the causes, true causes of the migration. Sorry for being outside of that.
Dear Professor, thank you for being so exhaustive. And if I may, just one sentence before flooding Lithuania and other neighboring countries with migrants. So Lukashenka's phrase was that we were stopping migrants and drugs. Now you will catch them and eat them. So this was an open declaration, you know, of participating involvement of this, and including with other public authorities. And as was mentioned by Professor in the start of this conference, including the courts, the Constitutional Court of so-called Constitutional Court of Belarus itself. So thank you so much, and time flies, and that is why I would like to invite Mr. Vytis Jurkonis to address the involvement of Belarus in the broader geopolitical context, because everything we can see everything better from a distance, and we cannot, you know, predict the course of history, but time tests unity, friendship, and also the human capabilities, even if we speak about the current war in Ukraine. And everything is so interrelated. The so-called migrant crisis, whatever we call it, was also in response or followed the sanctions applied to Belarus regime and also the activities of the opposition. Yes, and so the connections between Russia and Belarus. So Belarus' position from being as a mediator, when we speak about, let us say, the situation in Crimea and what we have now, turned from mediator to direct participant. But when we speak about migration, so again, this has a broader geopolitical context. So, dear Mr. Jurkonis, please present your points, if possible, a little bit in a shorter time, but we are really delighted to listen. No, Professor, we appreciate your insights. Thank you.
Thank you for having me here. I'll do my best to squeeze it into a couple of remarks. And I think I'm not going to match most of the expectations, you know, and I want to take my human rights defender's hat off here. Like, as a person who works on Belarus-related issues for more than a few decades, I think if an ordinary Belarusian from Belarus was watching this stream, he would be so sad and upset. Because basically and this is also the perception of the neighboring regime country. They are looking like, these guys are not capable of doing anything to us. I mean, we can do whatever. And I think that we need to change the thinking of dealing not addressing not the consequences, but dealing with the problem. Because Lukashenko might throw at us like the instrumentalized migration, disinformation, propaganda. I mean, have more political prisoners and force more Belarusians to flee. In fact, when we talk about the instrumentalized migration, usually we talk about the process which was taking place in 2021. But Lithuania and Poland was experiencing the huge flow of migration in 2020, mostly consisting of Belarusians. And that was also a hard hit, though we were like willing to accept them and understood that most of them flee because of the huge level of repressions and terror in Belarus. So, so in this regard, obviously, nobody argues that the process was intentional in 2021, and we had a harder stand on Belarus and its atrocities in 2021 after Ryanair. But I think that Belarus generally, Belarusian regime, is a perfect litmus paper for us whether the international system can be efficient addressing the authoritarian leaders. And in fact, that was exactly the case where like Vladimir Putin was kind of observing from the distance into our reaction towards what is happening in Belarus and how are we going to respond to the massive torture, like rapes, the increase of political prisoners, like and other sorts of brutal repressions. And in his eyes, like, we didn't make much progress except of resolutions, shaking hands with the Belarusian Democrats, promising the support to civil society. So I think that we need to be much more fierce in not only advocating for it, because when we had at the very first panel, Mr. Latushko, he said, like, what next? Like nuclear bomb, and we have the nuclear shipment going from Russia. So the fundamental question is, like, are we going to deal with the problem, not with the consequences? Though we need to deal with the consequences, obviously, treat the migrants according to the international law standards and all of that. And I think that to the best capacity that we can, we are trying, and there's still a lot of potential to improve. But the problem I see that usually we would see folks from the UN, Red Cross, and other institutions coming to Poland, Lithuania, saying what we need to do, like, meanwhile, they are totally inefficient inside Belarus. And I thought for a minute in 2020 that that's partly because most of the folks at the international organizations, they are saying, like, you know, that's domestic affairs. Let's not interfere into that. That changed in 2021 because suddenly with the Ryanair story, that became a regional problem, and like with the elements of the terrorism type of behavior and the instrumentalized migration became a regional challenge, right? So in this regard, the very recent thinking within the EU regarding the pushbacks was like that we need to find some technical solution, you know, impose 20,000 euros sanctions, fines to those who are like doing that kind of stuff. And the question is, why are we discussing it only within our circle of like-minded people? Can we actually do the other steps, saying like for every person of the illegal crossings, like we're gonna put a fine to the Belarusian regime, and that because this is exactly what they are doing, intentionally putting that on us, on the EU, so we can do the counting and put the fines. Similarly to many Belarusians who face all sorts of challenges, health condition, really poor health condition, burnout, and many things like that. They are in need to cover their medical costs, and various foundations are trying to do that when some people are asking for asylum. But again, like Lithuania, Poland, and other states could actually do the calculation, do the medical treatment and services for free to all Belarusians, and do that calculation and send the bill to the Belarusian authorities, because they used to bear their taxpayers. And you know, when you do that kind of stuff, the mentality of Belarusian regime is like, okay, that's kind of another gameplay that they are not expecting. So I think we need to kind of go beyond the usual standard thinking in terms of like resolutions, shaking hands, making promises, organizing conferences, but be less on the defensive mode, but more on the offensive. If you want to fight with us, let's fight, but perceive it as a fight and look for the solutions where we can impose things. And to be honest, with again, I've heard many things about saying like the abstract Brussels, that we didn't do enough. Similarly, that there's an abstract or regime. There are concrete names who are behind that. Instrumentalized migration as well. Those who are in charge of the border control, those who are in charge of the instrumentalized migration, with all the cyber partisans leaked databases, we can count every single person, every single person. We have even here in Lithuania, folks who used to work for the border control, folks who used to work at the migration department, they know their colleagues. Every single perpetrator might be counted. We are doing that with judges and prosecutors. We can be way faster, and in fact, organize less conference, but do more actual work to make sure that this impunity is addressed. Thank you.
Yes, our both panelists really deserve applause, and I thank Mr. Vytis Jurkonis for his strong insight that majority of us, of course, support, and for many of Belarusians and now Ukrainians in this war, these topics, these are not even topics for discussion, because in addition to hope, in addition to courage, we need action. So each movement, our unity, so everything matters. And now I'm very glad to turn to my right and to address our guest from not so far, but still to travel to both sides, Latvia, and here we have Excellence Ambassador, Mr. Edgars Bondars. And so much in my head, but the key message or underlying, issue, this so-called migration crisis is that it was a little bit, at least our three states felt a little bit unfair because, Strasbourg Court and all NGOs, issued those whether it be interim measures, whether it be recommendations or reports, saying that those countries, they violated prohibition to torture, to individual examination of asylum seekers' applications, that they should not expel, them. And we realized that this was perhaps not the correct forum to ask for Belarus responsibility, because the underlying message of asylum international laws are based on social humanitarian concepts, and dear Ambassador, would you please share what's in your head, in your heart, about your experience of your state in this situation? That's our topic for our panel today.
Thank you very much. Distinguished Madam Minister, distinguished participants, ladies and gentlemen. My name is Edgars Bondars. I'm representing Ministry of Foreign Affairs of Latvia, and I'm ambassador at large currently for migration issues. I started this portfolio this year. Last year I was dealing with the preparation of Three Seas Initiative Riga Summit, which was held exactly 1 year ago on 21st of June. But migration, Three Seas Initiative was about connectivity, but migration is connectivity in different other meaning. Anyway, 2 years ago I was still working in Warsaw, when my very good colleague and friend, the Lithuanian ambassador, approached me and started to talk about that there's a migration crisis on Lithuanian and Belarus border, and I was curious what is it and how it is developing, and he was very upset with that things are developing so fast. And in a couple of months, at the end of the summer, Latvia also was dealing with a migration crisis, and our reaction was, thanks God, was quite fast and sufficient, and cooperation between services with Lithuania and Poland was, I would say, successful, but still migration crisis was there. We know that it was planned and orchestrated not only in Minsk, but most probably in Moscow as well. And in this regard, I would say that there's now a little bit angle of this migration crisis, and we can see Belarus more like experimental guinea pig for Moscow, and that this migration crisis is test for security and resilience of all our three countries, by not by Minsk but by Moscow mostly. Speaking and about what if Moscow would make migration crisis more tougher and send also over the border with other EU countries, which is Latvia and Estonia and Finland. And in this regard, I would say we have to think also on these terms, because there are information that which is not very positive. For example, that Russia and Iran made a visa-free regime starting this year, and there are already about 260 tourism companies of Russia who is getting certificates to work for Iran. And what's next then? Okay, it's not maybe not the nuclear bomb, but what they will maybe approach the other countries in Middle East, or at the end release their prisoners and then push towards our borders, which, you know, some similar things happened for private company Wagner fight in Ukraine. So it is possible. Instrumentalization of migrants, it's a very hot topic which we are pushing quite intensively along with the Lithuanian and Polish colleagues in Brussels. We are waving as much as possible flags in different groups in Brussels, and thanks God we are not alone, and Germans or Scandinavians, they are understanding that they are understanding that true target countries are those more in Western Europe, not Latvia, Lithuania, and Poland, as it was also said in the beginning by Prime Minister. I think that yes, there are actually some good signs as well. Like recently in Brussels, there were a conversation. There is constant conversation with the Iraqi representatives, and recently there was some development, and Iraqis agreed in favor of non-voluntary returns, because there are strange provision in the Iraqi constitution. You might know that Iraqi citizens are kind of allowed to choose where they would like to live, wherever in the world, not Iraq or other country, which is a strange provision, and that's why the legal term non-voluntary return was kind of under discussion. Now, I think that there are many symbolic meanings for different things. For example, like recently was issued arrest warrant for Putin and Lyova Belova from International Criminal Court, and reaction was simply amazing. It was effect like a bomb in different sides of TV screen, let's say, and in different sides of the world. And I think this is a very good example of symbolic example. Like also in 2001, arrest of Slobodan Milosevic was also very symbolic one, and it was clear example of how one leader is brought to justice. I have some notes regarding United Nations, because about 20 years ago I was dealing with the multilateral issues and working for United Nations, and I just remember in the beginning of today's conference there were many young people, and I just remember that 20 years ago it was not only Slobodan Milosevic, it was also Millennium Development Goals, it was also a high-level panel for threats, challenges, and change, if you remember. And this panel was coming out with recommendations and stating that there are 10 real threats for the future, including genocide and interstate war, and civil war and environmental issues. But there was, I think, 11th would be tyranny. If they would make a prediction for that, it would be really right. Well, I would stop here. Thank you very much.
Yes, thank you, the Ambassador. We still, I hope, have energy after our honored last panelist, Vice Minister, to have a brief discussion. So now I'm very happy to invite Vice Minister of Justice, the Republic of Lithuania, Ms. Gabija Grigaitė-Daugirdę, who is really, well, she has much to do. In addition to being one of the organizers, together with the Law and Democracy Center, also in everyday work, because Lithuania was very, very brave and active in, if to speak about Ukraine, initiating the processes before international courts, and one of those pioneers of the 33 states which applied for intervention into proceedings against Russia. So if we speak about Belarus, so perhaps we still, dear Gabija, can we anticipate the same courage? Where is the source of courage of Lithuania? And do we have legal ground? And can we anticipate some similar activity and effort when we speak about seeking of the Belarus responsibility?
So thank you, and it's really nice to see that quite many motivated and committed people still left, having that patience, to hear the last panel that we are having. So yes, Indra, it's all about motivation, one thing, but the other thing is about human resources also. And within ministry we have 2 persons working with the accountability file. It's me personally and my colleague sitting there in the room, and you can have an idea how effective you can be with having 4 hands. So as much as you can be effective, we try to be effective. And I think I would agree with Vitis on the point that less conferences, more real work, because I think today is a very good example how to consolidate the effort in the end, because we have NGOs working within the files. And sometimes what is needed, more trust from the state institutions on the information that NGO sector possess, because sometimes we sort of have that standard of evidence being put that high that we sort of look at the NGO sector with very big cautious. Somehow, not wanting to trust them for one reason, but at the other end, being without hands to get the information that they have. And where to draw this balance is really, really hard. So it might be, political priority in the end, making sure that you better trust instead of having no way forward. So I think, the conferences like that, even though I agree that more real work can lead to better results, but I think this is a very important platform to show the NGO sector that they can be trusted and they should be trusted, because they do enormous stuff of work. And they can be that additional hands for the state institutions, making sure that they actually have more possibility to start legal procedures and to sort of start accountability efforts together. So that is my sort of wish for the future, so that we find better ways how we can understand, first of all, and then use each other for the very common purpose. So now about these real works. So as you are all aware, I hope, you know, that we did a quite good communication in the end, even though having both 4 hands only. But the Ministry of Justice has proposed and the government has approved to initiate an interstate dispute with Belarus regarding the smuggling of migrants to the territory of Lithuania. And yes, I agree with Professor, we can, you know, lawyers can spend days on discussing the definitions, you know, and how it should be called in one way or the other way. But in the end, you know, as the information started to come, you know, and the information has been put on the table that there is evidence and information that actually allows to conclude that irregular migration and massive border violations were organized with the involvement or in most cases even assisted by Belarusian institutions or entities that were subordinated to the Lukashenka's regime. And you immediately then, you know, ask yourself, do you take it for granted and you do nothing? Or you at least having, you know, seeing the reaction that we had from the international organization saying that, you know, we have to deal with the consequences, but everything is fine with the regime. That is, you know, in Belarus, like you take it as a consequence, but you do not deal with a problem. So we thought that actually we should deal with the problem, at least try to do that. Because, you know, all the information, you know, that they were starting organizing these additional flights and they eased, you know, the migration policies. And there were even, you know, like evidence that they actually used the transportation means, you know, to sort of help them, you know, to get to the border quicker. And, you know, they even provided means and instructions, you know, on the routes that they should be used. And with the communication on the regime side, the one that you, Indra, indicated to, that was said very directly that I will flood Lithuania and neighboring states with migrants and drugs. So, you know, sometimes you can think that it is, you know, just a saying of a crazy man, but you understand that when you realize that it's happening for sure, you ask immediately, so what else do you have to wait for? And that is why, you know, especially if you take the numbers, you know, because for international organizations, sometimes, you know, we get lost in this like natural migration flows, but, you know, the statistics are there. Yes, I agree that, you know, there are always people under the statistics, but if you take statistics, you know, for example, in 2019, we had like 74 illegal migrants arrived. In 2020, we had 37, while meanwhile, in 2021, we had more than 8,000 attempts to legally cross the border. And in 2022, we had almost 11,000. So you understand that, you know, without the direct involvement of the state, it would be hardly possible because, you know, we immediately started looking at the international obligations that might be there. And we discovered that, yes, we have protocol that was quoted by the professor on the illegal entry of migrants by land, sea, and air that supplements the United Nations Convention Against International Organized Crime. And we realized that very clearly, you know, Belarus has obligation to control illegal migration. We have to start talking about effective border control, the obligation to cooperate with Lithuanian officials to make sure, you know, that it is being avoided, and not to encourage illegal migration in any way. So if we think about organization of those additional flights, you know, so it hardly, you know, meets the international obligation that Belarus have. And the interesting thing, I would not go into the details, you know, about simplifying the visa regime or what I have mentioned, is that before the last notice by Lithuania on the interstate dispute, hundreds of notices by border agencies and tens of diplomatic notes were issued, and we never received any explanation or even recognition of situation. But as soon as we put it in the legal language for state responsibility and claiming, you know, for compensation of damages, they did answer. So we can, think that sometimes the legal efforts, they, searches for justice, they do take time, or, that international law is not effective, and you get those arguments, in every conference that is being organized saying that, we cared that much about development of the human rights framework, but we never thought about what effective mechanism, legal mechanism, should be there for the brutal regimes that keep violating that human rights that we promised for all. Because international community made that promise saying that, look, now we talk, and suddenly we stopped having, human rights violations as internal business of the state, and we created and developed that much human rights, treaties, giving that promise to all the people. But we lacked time and political will to think what we do afterwards when we have Putin, Lukashenka, and all the other dictators around the world. So the interesting thing is that in the end, when they understood that, the damage claim is on the table, so they did answer. Because when you only write saying like, look what you are doing, they think what Vitas, I think, rightly indicated, like, what are you going to do about it? Like, just keep writing, and we will keep putting it on the shelf. But when you suddenly get, the sum of money that you are going to claim for, they sort of take a notice and they answer. So I think that, I will not go deeper because I think we still can leave some questions, to handle. But, as I always say, it is very important from the standpoint of law, and it is of crucial importance to make sure that, and one of the claims that we're raising, to make sure that we have international responsibility of Belarus being stating, so that we have this statement, that institutions are being involved, that they are being aware of what is happening, that they have, by their, intentional efforts, they have created that situation, and that we have to pay for that. So thank you.
Thank you so much, dear Vice Minister. We need, in the path towards responsibility forums, including international courts, the ICJ. That's why we need to prove jurisdiction, and those, correspondence, I believe, will help because each dispute is limited. And when we search for the basis of jurisdiction, as the ICJ recognizes itself, so the dispute is always wider than the specific convention allows us to have the case before it. So now, just a very brief round of a few questions, a few from me, perhaps from the audience, and I would like to address, first of all, Professor Alexander Rubinovich, with the invitation to continue Vice Minister's insights on the path towards justice, the need of motivation and action. And dear Professor, you demonstrated us a rather long list of conventions, treaties that have been violated. Perhaps they are suspended now, or the fate is similar. But when we speak about responsibility, so perhaps part of those conventions may serve for proving jurisdiction, because there have been so many instances when we saw that limitations of state responsibility. Yes, in a case against the Serbia, Montenegro, we remember the case that the state was not recognized responsible for atrocities, for genocide, merely from failure to cooperate in transmitting Ratko Mladic to international tribunal to cooperate, and now Ukraine is again fighting and doing incredible job in proving again jurisdiction and on the convention, on the basis of the convention, for example, the suppression of the financing of terrorism and elimination of all forms of the racial discrimination, the proceedings oral part are right now at the ICJ. And we also remember that Sakartvelo, Georgia, failed to have that justice in terms of the decision on the merits because due to procedural issues, including the failure to negotiate, what was a precondition. So dear Professor, could you just share without your thoughts, how optimistic do you feel about using at least part of those conventions for having international cases before ICJ?
Okay.
It works.
Well, so it's a very difficult question because on the one hand, it is quite clear that some of this convention may serve as a jurisdictional basis. But my question and my fear, my general fear is what if the withdrawal from the optional protocol to the International Covenant for Political and Civic Rights is this was exactly what some months ago, if I remember well, Lukashenka did. He withdrew from the protocol, effectively blocking the possibility for individuals to lodge claims before the Human Rights Committee. What if he will continue in the nearest future this tactic to withdraw from any kind of treaty which could eventually serve as a legal basis for claim against the ICJ? It was quite interesting to observe that, to hear about your proposition about money. So excellent, but now, okay, you have the bill, you send this to the Belarusian embassy, and then what? How to? Exactly, but on the other hand, the problem is that if I know such dictators like Lukashenka, who is supported by the permanent member of the Security Council, I mean Russia, and could be that also Chinese government could offer some support in such a sort of struggle, then I don't think the idea sounds great, but how to put it in motion, it is totally different story. Of course, we could eventually draw our attention and to use the countermeasures. So perhaps we could eventually seek for a property of Belarus localized within the European Union, but I'm afraid that most of this property is protected by the diplomatic immunity, and of course, as it is clearly demonstrated by the recent case in Warsaw, not every premises of the Belarusian embassy, of Russian embassy, which used to be used for the diplomatic purpose, is immune, simply because if at the moment when the court issues the decision, the premises are not used, in such a sort of situation, the immunity doesn't work. But nonetheless, I'm not optimistic to find too much property to be seized for the purpose to cover the cost you indicated. Because, well, sounds great, but on the other hand, it is quite difficult. And of course, if it is about some basic standards of the international law, notably first the Tortures Convention, so long as Belarus is the party, if I remember well, but I must check, this convention could eventually serve, and probably some of the treaties indicated here, as a basis of jurisdiction, but I'm not in position to give you the clear information. If you want to have more on the issue, I must simply check, because I'm not prepared to answer this question. But anyway, it is general premise of jurisdiction of the ICJ that every litigating party must consent to the jurisdiction, and if the judges of the ICJ come to the conclusion that this condition is not met in such a sort of situation, we are once again at the same point, and the starting point.
Dear Professor, thank you so much. Mr. Vytis Jurkonis, would you please, and then I will invite our dear ambassador to conclude in each of you in some 3-5 minutes, your final thoughts about, and I'll refer to Mr. Vytis Jurkonis on his insights on will this remain one more Europe's or world's broken promise, because we had never again, when we speak about the international community's responsibility for redress of the victims of atrocities and simply to prevent such things as crimes against humanity happening. But in the first, perhaps, session, I have heard such phrases as perhaps we missed the right time, with the right opportunity. So, David, how do you think? Is this perhaps that moment when we may say that it's of course, we always may say that better later than never, but in the present time, the moment, the given moment, the given geopolitical situation, how the situation, contributes to the success, our success in seeking for Belarus responsibility?
Yes, I think that kind of argumentation, this is exactly what Lukashenko wants. This is because, nothing is missed. The public demand, for change is there. We know it's there. The Lukashenko, as he was illegitimate, and his regime remains to be illegitimate. Human rights violations and terrorizing of the population continues, and all sorts of other sorts of human rights violations, and violations of the international norms. And you need to have the bill and keep counting. Because if we say that, it's makes no sense because nobody is going to pay the bill, I do believe that for the regime it's important to name names and to have the bill counting, even if your colleagues from Poland and my colleagues from Lithuania and many international diplomats met Andrei Savinych, who is there sitting, and I don't see a problem of lifting all the immunities, and his daughter is, by the way, in London, working for the banking sector. Guess where? In compliance sector. Why? We know why. Because someone is bypassing sanctions. And all names can be named, and every single perpetrator might be counted. The fact that they are violating international norms cannot be an argument to say, because the regime is counting on this, that you will say, I'm not going to fight this, I'm not going to look for the alternative solutions and all of that, because that's the way usually it works. And here I'm coming to the question whether we missed the chance. Again, Lukashenko said that in some interview, I think, with Margarita Simonian. Let's turn that page. He wants us to turn that page and to get back to the process as usual. He did that in 2009 and 10, and that worked. He did that in 2004, and that worked. And he counts on that and it is important to have a different narrative to say this will not work again. Similarly, Russian regime is counting on that too, because they perceive in their eyes Lukashenko's regime is very weak, and if we cannot do anything regarding him, regarding Lukashenko's regime, despite the fact that the public demand is there, the terror is continuing, that the impunity is not being addressed, I don't see why we need to come with the position, what do we do now? We need to do what we ought to do if we are really not only talking, but actually implementing the defense of the human rights, democracy, because the next phase for the regime is going to be, let's come to the bargain. I will release 10 or 20 political prisoners and you will lift the sanctions. That's what they are expecting. And when we come to that bargain, we say yes, we might have that bargain, but here's the bill that we also have. Because it's there, it's counted by us. It's a clear, and you said that, it's a clear violation of all international norms, so you are not getting away. If you want to have a conversation, a debate, a bargain, whatever. So it's important for that bargain as well, because at some point, you'll come to that place, and some official, and we know that the Switzerland is doing that, Austrians are doing that, so we need to have that bill for that bargain, because the regime expects us to get to the business as usual.
Thank you so much. And dear Ambassador, in many discussions, also including with diplomatic agents, they are always for diplomatic means, yes. And once I heard opinion that you can be a star for mass media saying that someone deserves prison or that The Hague is waiting, but perhaps you are too small, or perhaps Russia will still sit at the negotiation table. So what's your feeling? May we count on diplomacy, or is this, as in case of Ukraine, when there is no feeling, at least from Ukrainian side, for that?
Well, there is no point of return in certain way, I think. But if I'm not mistaken, today in news was that Silvio Berlusconi passed away. So no one lives forever, and I think if in Belarus or Russia situation will change upside down, still justice should be served. I'm a lawyer by education myself, but I turned to diplomacy, unfortunately. Well, no, because I pay my respect to what I hear today, and I really appreciate the work of colleagues here, and I evaluate very highly the law and work of lawyers. So I think anyway, situation will be changing, but justice should be served, and evaluation of all the things should be there, and no one will get like this away. So yeah, rule of law.
Much appreciated. And may I continue the thoughts on the rule of law? We have agreed with the Vice Minister, as I have today overlapping events, and so I have to leave. So Vice Minister was very kind to take the questions from audience, if we have any. But before I leave, I want to cordially thank you, the organizers, the Law and Democracy Center, the Minister of Justice, and to thank each panelist of this session, which proved both that there are illegal actions and also attribution to Belarus when we speak about the responsibility for this illegal migration. And let me conclude that Belarus, well, is a unique phenomenon. It's like a Russia's watchdog. Even if toothless, but still having arsenal of weapons, whether it be Astrovets nuclear plant, whether it be repressions or migrants. And it also demonstrated its face each time voting against in resolutions, GA resolutions at the United Nations in this war against Ukraine. But speaking about migration, hiding behind someone's back does not guarantee avoiding responsibility. Suppression of free speech does not mean changing people's mind, and remaining aside multilateral conventions or like a black hole does not mean that the international law does not apply. So we need, of course, courage, motivation, but what we need is action. And let us hope that this nice palace, which is the second year for discussion of the responsibility of the authoritarian regime, next year will be the place to well establish and to discuss, to speak of results, of achievements of our not moral but also legal obligations to help those people, the victims of repression, who deserves dignity, and international community who undoubtedly deserve the victory of the rule of law and humanity. I cordially thank you for allowing me to participate in this conference and to chair over this discussion. Thank you. So the final word is, of course, for the Vice Minister, Gabia.
So I think we have like, I don't know, I'm looking at the professor. I think we still have like 5 minutes to have 2 questions from the audience. So I don't know who was the first, Marika or the gentleman in the end, but please take the floor.
Thank you. Another news item today was that Canada and the Netherlands have gone to the International Court of Justice under the Convention Against Torture against Syria. So a couple of years ago, the Netherlands had already held Syria accountable, started negotiations. Canada joined it in 2021. And today they announced that a couple of days ago they've submitted to the International Court of Justice. And maybe you're not going to like this question, but I thought it was going to be appropriate for today, as we have the ambassador to Latvia and the vice minister to Lithuania. Is this something that your countries could consider, bringing an ICJ case under the CAT against Belarus?
So I will start maybe. We have had many discussions, you know, and it's not only Ministry of Justice making the final decision. It was Ministry of Foreign Affairs, and we had also government lawyers, and we made the decision, you know, that the legal source that we are referring to entails less risks. Because, you know, we do not want to be in the situation that we will have to explain ourselves in International Court of Justice, because Lukashenka will straightforward bring that issues against us. So that is why, you know, we consider that, grounding our claim on the protocol entails less risk than going under the Torture Convention. So that is my short answer to that.
I think this will be the case where diplomacy will be serving justice. Well, but I completely agree with the Minister.
So, okay, so here is the time for the last question then.
Thank you. My question was actually about the same development. And there is no reservation on behalf of Belarus to Article 30 of the Convention Against Torture. And this initiative by Canada and the Netherlands to unpack Convention Against Torture opens ground for other states parties of the convention, not necessarily Lithuania or Latvia. There are almost everyone. And it's important because the respondent in this case, Syrian Arab Republic, is another watchdog of Putin. So this is breaking ground. And this is something which I think will be discussed in the future, particularly because of this groundbreaking case. And something which opens some avenue for accountability without necessarily establishing new institutions on the framework of the institutions which we already have. So that was my question.
So, you know, I would start maybe a little bit with a little bit flashback to the last year, because sometimes, you know, what I feel, you know, in the corridors of different political discussions, that, you know, we have the idea with atrocity crimes, it should be easier than with, for example, crime of aggression, for the one simple reason that atrocity crimes seem to avoid, you know, the need for very complex political judgments. And, you know, last year when we had the conference on the crime of aggression against Ukraine, it was hardly believable that, you know, after 1 year we will have even the United States of America supporting the idea that Putin should be brought to accountability for the crime of aggression against Ukraine. And sometimes, and I had this idea in the morning during all the panels, that sometimes we need the legal qualification sort of to give us additional argumentation for why we do it or why we don't do it. Because, massive and systematic human rights violations in Belarus, they haven't started, last year. And I think you were talking about, that we should talk about not, only the post-election violence, but all the things that were happening before that. And sometimes we should ask the question, so what international community is waiting for? Because, if you remember Darfur case, it was big expectation that international commission would fight genocide in Sudan. And suddenly, international community had no idea what to do when only crimes against humanity were found. So sometimes, we put ourselves in the search for legal qualification, thinking that it might ease the path or it might sort of create, easier ways for politicians to make the decision. But, if you have, political will and if you have motivation to do it, you will always find legal qualification that would allow you to make the action. So sometimes, the search is for very precise legal qualification. It's just, to win the time. And so maybe that served sort of instead of conclusion, but but I think it's time for us to make the conclusion. And I invite Professor Jalemas here to have the last few words for us, and then we invite all of us and all of you to the reception, and just a short notice that you should find yourselves by going via cafes. So I mean, it's like logistical information, but so I make sure that you do not run away. So thank you, and please, Professor, take the floor.
Thank you, dear colleagues and friends. I really will try to be as brief as possible. Those who participated last year in the conference, you remember that we, at the end, we issued the document which was called Vilnius Communique, just in order to reflect the discussions of the conference and also to express our key, let's say, thoughts and recommendations. The same pattern we are going to follow also in respect of this conference. Of course, I have the draft which is called Vilnius Communique 2023, because last year it was now Vilnius Communique. But I propose to do in the same way like we did last year, that we all circulate the draft to all the panelists, because we are actually issuing on behalf of the panelists. And we'll publish, in our website, as well as probably in the website of the minister a little bit later, when we receive the feedback. Your proposals, the objections, if any, so when we'll decide. But I hope, actually last year I remember we all took into account all the proposals and editorial especially. So I think this will not be a problem. And actually we'll release to the public this communique a little bit later. Therefore, I'm not going to read all the draft. Actually it describes the structure of the conference, why it was called. Also reflects a little bit the content of the discussions. I will read only a few main, let's say, recommendations at the end, or the position, because I believe that this sometimes can be important also for other bodies, for international organizations, for governments, because last year I remember Vilnius Communique was referred to in a number of times by, first of all, by Ukrainian government, by other governments who actually continue to pursue the idea of the establishment of a special tribunal for the aggression against Ukraine. So the main points, let's say, are as follows. First of all, it is expression of support for all the national efforts already undertaken under the principle of universal jurisdiction to investigate and to prosecute, to investigate cases and to prosecute individuals responsible for the crimes against humanity, because I believe there is general understanding that we really here, in case of Belarus, we are facing the crimes against humanity. Also, the call to expedite and coordinate national investigations carried out under this principle, under the principle of universal jurisdiction. I mean, with a view of naming concrete suspects and issuing warrant orders. And also not applying, it's better to say, to consider not non-application of immunity to Mr. Lukashenko. Also a proposal to the authorities of Lithuania, Latvia, Poland, probably also other affected states to consider the referral to the International Criminal Court. As it was mentioned, in accordance with the Bangladesh-Myanmar precedent, we have very narrow window to refer the situation to the International Criminal Court. Also, recommendation to consider the establishment of a special ad hoc international tribunal for the crimes against humanity in Belarus, encouragement of the creation of an active international network of interested lawyers, academics, and practitioners, also calling other neighboring states affected by migrant crisis to join Lithuania's efforts in seeking responsibility of the Lukashenko regime for smuggling of migrants in accordance with the existing international instruments. And finally, encouragement of the international community to consider more efficient modes of responsibility for the instrumentalization of migration as a means of pressure on other states. Maybe also what I heard will include, of course, a few sentences about the importance of collection of evidence, which was mentioned a number of times, and also probably the proposal to consider the idea of the People's Tribunal. So that's almost all, but of course all the panelists will receive the text, and afterwards, after your feedback from you, will decide on its release to the public. And the final words, on the one hand, it is said that we have to say goodbye to all of you. But first of all, I would like to express on behalf of the Center of the Law and Democracy our gratitude to, it seems, our traditional partner, the Ministry of Justice of the Republic of Lithuania, in particular to the Minister Evelina Dobrovolska and Vice Minister Gabija Grigaitė for being our partner, working very constructively together, sharing the same ideas and the same values, that is the most important. So maybe we hope next year to have another conference similar. It would be better, of course, to have something different as a theme rather than international crimes. Then I would like also to thank our own team, Aira Keturakienė and Inesa Stolper, who are working in the Law and Democracy Center, who also contributed a lot to the organization of this conference. I would like also to thank all the experts who prepared. By the way, I'm sorry, I forgot to mention, really, again, in a few weeks, it will be published, I mean, for the public, the study which is already at the final stage, let's say, of a preparation on the crimes against humanity in Belarus, with all the issues discussed here in a much wider Analysis will be provided, first of all, on the contextual elements, then on mental elements, so everything, specific elements for the concrete crimes against humanity, and so possibilities for justice, including International Criminal Court, universal jurisdiction, and the idea of a special tribunal will be discussed where. Who prepared the study? Our esteemed experts, Andrei Vasilyev, Maria Kolesova-Uzilina, and Marike de Hoon. So we are very grateful for their huge contribution to the success of this conference, and I mean, we also hope that this study will also make a significant impact for further discussion and consideration of the ideas how to bring accountable Lukashenko and his accomplices. And also would like to express our gratitude to all the volunteers who helped us in the organization of the conference, and certainly to our dear translators who were working hardly all the day. And that almost ends my conclusions. Once more, let me express our gratitude to all of you. Hope to see you next times in the conferences where we hope to analyze the progress made on both items, on tribunal for Russian aggression against Ukraine and on the accountability for the crimes against humanity. And let me finally express our hope that, as in case with the tribunal for the aggression, after a year of our conference, we see really remarkable progress. Let's hope that after a year, we'll also will be able to say the same about the idea of effective accountability for the crimes against humanity in Belarus. So thank you very much, and hope to see you also next year. And finally, as it was told already, it's the good news. So please welcome to a small reception. Also here, those who don't like receptions, you can go also nearby. There is traditional Monday meeting. I mean, each Monday here in Vilnius, there is a meeting in support of Ukraine, but also in support of Belarusian civil society. So you will be able to attend this meeting as well. So thank you very much, and see you soon.